Median is Varna.
Oh,
Yeah.
okay.
All right, good afternoon, everyone. If we can have everyone please rise and raise your right hands in both locations.
You gotta stand up, Ted.
Oh, no.
All right.
South County, I can't see. There we go. Hang on one second.
No.
All right. Do you all swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
All right, Ms. Hernandez, will you swear in the Spanish for me, please? Ms. Hernandez, can you hear me?
Yes, Your Honor, I'm sorry. Buenas tardes. Los que hablan español, por favor, digan, ¿juran ustedes decir la verdad, toda la verdad y nada más que la verdad? Contesten que sí.
Sí, sí.
Yes, yes.
Yes.
May be seated.
Pueden sentarse.
Hi, good afternoon. I am Judge Katie. You are here this afternoon for your first appearance hearing. There are 4 purposes for this hearing and 4 purposes only. First, I will advise you of the criminal charge that brings you here today. Secondly, I will ask if you have an attorney representing you. If you have hired an attorney to represent you and they are present here on your behalf today, they will speak on your behalf. If you have hired an attorney to represent you and they are not here today, then you will have to make a decision as to whether or not you wish to move forward today without your attorney present, or you can postpone your first appearance until tomorrow. If you elect to postpone your first appearance until tomorrow, it is your responsibility to contact your attorney's office to make them aware that you will have court tomorrow. No one else will make that phone call for you. Again, if you wish to move forward without your attorney, we can certainly do that. If you do not have an attorney, I will ask if you can afford to hire one. If you say yes, then we will move forward. If you cannot afford to hire an attorney, I can provisionally appoint the Office of the Public Defender to represent you. There is an application that you will have to fill out at some point. There is a fee for that application and a fee for the services of the public defender at the end of your case if you are found guilty or enter a plea of guilty or no contest. Third, I will address any challenges to probable cause if there are any of those. And fourth, I will take a look at your bonds and or other release conditions to determine if any changes need to be made to those. Please be aware that you have a right to have your attorney present with you before and during any questions or any questioning. Please be aware that if I place you on pretrial release today and one of those conditions is no contact with the victim, that provision begins while you are in custody. That means you cannot have contact with any victim or witness that is ordered today while you are in jail. If you do, that is a violation of your pretrial release. It would result in your pretrial release being revoked and potentially result in an additional charge, which is a misdemeanor of the 1st degree. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where all of you are located, is being recorded. There is an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through this entire process. When your name is called, you will step up. Ms. Hernandez, would you do the speech, ma'am? If you'll raise your right hand for me first. Do you swear to interpret from English to Spanish and Spanish to English to the best of your ability?
Yes, I do. For the record, Clarissa Hernandez, Your Honor.
Thank you, ma'am.
Buenas tardes, les habla la jueza Peri y esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si ya le está representando un abogado. Si ya usted ha contratado un abogado y este se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla para mañana. Si usted decide posponerla, será su responsabilidad contactar a su abogado para hacerle saber que usted tendrá una audiencia. Nadie más hará esto por usted. Si usted desea proceder sin su abogado, puede hacerlo. Si usted no tiene abogado, le preguntaré si usted tiene los medios económicos para contratar uno. Y si usted puede, tomaremos nota de esto y procederemos. Si usted no tiene los medios económicos, pero califica, el juez asignaría provisionalmente la oficina del abogado de oficio para que le represente, en espera de que usted llene una solicitud por estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, voy a estar revisando sus fianzas y otras condiciones de liberación con usted para determinar si es necesaria cualquier modificación. Debe saber que si el juez lo pone hoy bajo libertad condicional, independientemente si es directamente o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún encarcelado. Por ejemplo, si se le ordena no tener contacto con determinada persona y usted llama a esta persona desde la cárcel antes de salir en libertad, usted estaría violando su libertad condicional. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde ustedes se encuentran, está siendo grabado. Hay un abogado de la fiscalía presente escuchando todo lo que se dice, así que no diga usted nada sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Favor pasar al frente cuando se llame su nombre. Gracias. Thank you, Your Honor.
Thank you, Ms. Hernandez. We're going to do an inmate who's here in person before we start the Spanish. Calvin Ross. Mr. Ross, if you could step down, please.
There it is.
And sign. Can you let me sign?
You want me to sit here, Judge?
You can sit there. So you're here charged with 3 counts of resisting an officer with violence. Do you have an attorney?
No.
Can you afford to hire one?
Think so.
You think you can?
Good.
All right, sir, we're going to indicate that you're going to hire your own attorney. I do find probable cause for each of the 3 charges, sir. Your bonds are going to be set at $5,000 on each count. Your next court date will be May the 19th at 8:15, sir. Thank you. All right, Ms. Hernandez, we have Amari Abreu Gonzalez.
Amaury Abreu González.
You are here on warrants out of Orange County.
Usted se encuentra aquí por una orden de arresto dictada desde el condado de Orange.
And they are a no bond holds.
Y esto es una orden de retención que no tiene fianza.
We are going to notify Orange County that you are in our custody and ask them to come and pick you up.
Van a notificarle al condado de Orange de que usted se encuentra aquí para que vengan a recogerle.
If they do not pick you up by April 22nd at 1 o'clock, we will bring you back to first appearance.
Si ellos no han venido a recogerle para el 22 de abril a la 1 de la tarde, lo volveremos a traer a esta audiencia para que comparezca una vez más aquí.
Thank you, sir.
Gracias, señor. Ya terminó.
¿Puedo preguntar algo?
Sorry, ¿qué dijo?
Si puedo hacer una pregunta.
Can I ask a question?
What's the question, sir?
¿Cuál es la pregunta, señor?
Sí, yo este caso lo tengo abierto por allá desde enero. Yo no me presenté a corte porque estaba en custodia de ahí. Yo quería saber si ya tengo alguna oferta por allá y la pudiera coger por aquí.
Okay, what I want to know is that this case that I have at the other county, I have that case open since January or February, and I don't know if they have an offer for me and I can take that offer from here.
No, you cannot do that. He has to go back
No.
to Orange County.
No puede hacer eso, señor. Tiene que regresar al condado de Orange.
Ok, gracias.
Okay,
Thank you.
thank you.
Luis Almazan.
Luis Almazán.
Has to be heard on this one, Judge.
Sir. So you are here charged with burglary with an assault or battery.
Señor, usted está aquí acusado de un cargo de robo con asalto, amenaza o agresión física.
You have an attorney, sir?
Señor,
Ah,
¿tiene
no.
usted un abogado? ¿Tiene usted un
No,
abogado, señor?
No en este momento, señora.
No, I don't have one at the moment.
Can you afford to hire one?
¿Tiene
I
usted
like
los medios, ¿tiene usted los medios económicos para contratar un abogado? Por favor, déjeme terminar, señor. ¿Tiene los medios económicos para contratar un abogado?
Me gustaría que me dieran uno del estado por ahora.
I would like to have one appointed by the state for now.
The question is, can you afford to hire one? That's a yes or no question.
Okay, la
No.
pregunta fue, ¿tiene usted
No.
los medios económicos para contratar uno, sí o no?
No,
Sir, if you need an interpreter, then you need to be quiet until she finishes talking.
Señor, si
Está
usted
bien.
necesita la intérprete, tiene que permanecer callado hasta que la intérprete termine de interpretar.
está bien. Lo
That's
siento.
fine. I am sorry.
Sir, I will appoint the office of the public defender.
Voy a nombrar entonces a la oficina de abogados de oficio.
If you find probable cause for your charge,
Encuentro motivo fundado para el cargo.
Mr. Matthews.
Señor Matthews,
Your Honor, the charge is a punishable by life, first-degree felony.
Su señoría, el cargo es un cargo que puede ser castigado con cadena perpetua. Es un delito grave de primer grado.
The allegation is that the burglary was of a dwelling, which is an enumerated dangerous offense.
El alegato es que el robo fue de una residencia, que ese es un delito peligroso de lo que está nombrado.
They request the court hold the accused no bond as he is not entitled to a bond.
Y la fiscalía solicita que la jueza retenga al acusado sin fianza, porque él no tiene derecho a una fianza.
State would respectfully note that the affidavit lists his address as unknown.
Y también hago notar a la jueza que aparece en el affidavit que su dirección es una dirección desconocida.
Further,
Una
the
direc-
defendant is currently out or was out on bond in CF 258196.
Y además, él también se encontraba afuera bajo fianza por el cargo CF 258196.
That case included a charge of resisting an officer with violence.
Ese caso incluía un cargo de resistirse a un oficial con violencia.
State will also request the defendant's bond in that case be revoked and he be held no bond pursuant to Parker.
La fiscalía también solicitaría que la fianza del acusado en ese caso fuese revocada y que se le retuviera en la cárcel sin fianza de acuerdo a la ley de Parker.
State would also note that his criminal history appears to reflect two adjudications for burglary.
Y también quisiera hacer notar que sus antecedentes también reflejan que tuvo 2 adjudicaciones de culpa por cargo de robo.
One as an adult and one as a juvenile.
Uno de ellos fue como adulto, el otro fue como menor de edad.
Thank you.
Gracias.
Sir, you are going to be held no bond on this case.
Señor, se le retendrá en la cárcel sin fianza en este caso.
Your next court date will be May 19th at 8:15.
Su próxima fecha de corte, señor, será el 19 de mayo a las 8:15.
What?
I am also revoking your bond in 20, ma'am, be quiet. I am also revoking your bond in 25 CF 8196.
Y también estoy revocando su fianza por el que tenía usted en el cargo 25 CF 8196.
Pursuant to a finding of probable cause in this case,
De acuerdo a una determinación de motivo fundado en este caso,
you will be held no bond pursuant to Parker versus State.
y entonces se le retendrá en la cárcel sin fianza de acuerdo a la ley de Parker versus la fiscalía.
You have an attorney in that case, sir.
¿Usted
sí,
ya tiene un abogado en ese caso, señor?
sí, su señoría.
Yes, Your Honor.
All right, ma'am, or sir, excuse me, thank you.
Muy bien,
Gracias.
señor. Gracias.
Ms. Hernandez, do you want to make an announcement? Those were the only names I was given.
Ok. Buenas tardes. ¿Alguien más va a necesitar español ahora? Por favor, levante la mano.
At Central, we have one, but he says he's Dominican. He needs a Dominican, a Romanian interpreter.
Yeah, we're trying to check on that for him.
You say 10 minutes.
Okay.
Oh, apparently we're gonna have one in 10 minutes. All right, thank you, Ms. Hernandez. We appreciate you. Have
You're welcome, Your Honor. Thank you very much.
a good day. All right, going to South County. State of Florida versus Kyle Denny.
Your Honor, Sanderson, Court Defender's Office. On Mr. Denny's, he's got two different cases. On the newest cases he has, I know on the docket it only shows one resisting without violence, but he's actually charged with 3 counts. And he's booked down on all of them. I have a stipulation with the state on 2 of the 3 resisting without violence charges out of his new case, that he should be released on his own recognizance on just 2 of those counts. But I believe the state wanted probable cause found for all counts, but on 2 of those, he can be ROR'd.
Okay. And the clerk does show all 3 of them.
Okay.
All right, so sir, you're here charged with battery with a prior conviction, battery on a firefighter or emergency medical personnel, battery on a law enforcement officer, and then resisting an officer without violence, 3 separate counts. Do you have an attorney, sir?
No,
Can you afford to hire one?
no.
Sir, I will appoint the office of the public defender to represent you on all of your charges. I do find probable cause on the battery prior conviction, battery on firefighter, emergency medical personnel, battery on law enforcement officer, and 1 of the resistings. The remaining 2 resistings, I do not find probable cause, and you will be released on your own recognizance on those 2 counts. Your bonds will be as follows: on the battery prior conviction, $7,500. Battery on a firefighter, $5,000. Battery on a law enforcement, $5,000. And the resisting an officer, it will be $1,000. Your next court date, sir, will be May the 19th at 8:15. Thank you, sir.
Judge, if I may, I
Yes.
believe I had a note that, never mind. I had a note that there was an open case, but it was a notice to appear case. Thank you.
Yes, I had that as well.
Yes, ma'am.
Thank you. Alexis Diaz Toledo.
Sanderson, Court Defender's Office. I do want to waive the reading of all of his charges. I think he has 1, 2, 3, 4, about 5 different charges. If he doesn't know what they are, I would ask if the bailiff or someone in the courtroom with him would show him what the charges are.
All right, who's our bailiff here? Mr. Nickerson, can you just, no, it's not.
Oh, just came wrong.
The judge of the state will be requesting GPS in this case.
House arrest or just monitoring?
Request comes from the CFA. He only requested GPS.
All right, sir, do you understand the charges against you? All
Yes, ma'am.
right, sir, do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds will be as follows: on count 1, $1,000. On count 2, $1,000. On count 3, $5,000. Count 4, $5,000, and count 6, $5,000. You do bond, sir, you are going to be on pretrial release. You're going to be fitted with a GPS monitor prior to being released from custody. You will call in to pretrial release every, what is today? Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have absolutely no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and or school. You will have no contact, not social media, third persons, phone, fax, telephone, email, any contact at all. Do you understand?
Yes, ma'am.
Your next court date, sir, will be May 19th at 8:15, sir. Thank you.
Thank you.
Pedro Ferritz.
Sanderson Flint Defender's Office. I do have a stipulation with the state regarding, all of the counts. There's a stipulation that applies. I think it'd be easier for me to say what we're agreeing that there's probable cause for versus what there's not probable cause for in this case.
That's fine.
We do both agree that there's, probable cause for the first count on the docket, the burglary tools, possession of burglary tools. We do agree that there's probable cause for one burglary of a structure, just one out of, I think he's charged with 3 or 4
One
of those.
burglary of an unoccupied structure.
Yeah, yes, one of those. And then we agree there's probable cause on the one grand theft over $10,000. And then we agree on probable cause for one of the criminal mischiefs. I think they're both the same,
Yeah.
but on all the other charges, we agree there's no probable cause and he should be released on his own recognizance.
All right, so you are here, sir, charged with possession of burglary tools with intent to use, 2 counts of grand theft, 3 counts of burglary of an unoccupied structure unarmed, 1 count of trespass on a posted construction site, 2 counts of grand theft of property value, 1 count of grand theft property value of $10,000 to $20,000, and then 2 counts of criminal mischief of property between $200 and $1,000. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No.
Sir, I will appoint the office of the public defender. I do find probable cause for the possession of burglary tools with intent to use, 1 count of burglary of an unoccupied structure unarmed, the grand theft property value between $10,000 and $20,000, and 1 count of the criminal mischief. The other charges, sir, I do not find probable cause for, and you will be ROR'd on those counts. Now, regarding bonds, sir, on the possession of burglary tools with intent to use, it will be $5,000. Burglary of an unoccupied structure, it will be $5,000. Grand theft, it will be $5,000. On the criminal mischief, it will be $250. If you do bond, sir, you will be on pretrial release. Conditions will include you contacting pretrial services in person upon your release, sir, and then you will call in every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with any victim identified in this case. You will stay 500 foot away from the victims, their homes, vehicles, places of employment, and/or school at all times. Do you understand, sir?
Yes, ma'am.
Sir, your next court date will be May 19th at 8:15. Thank you, sir.
Can I ask a question, ma'am?
Let me know when you're ready. Sir, I'm sorry.
Can I ask a question, please?
Hang on. What is your question?
What was the total of my bond?
They can tell you what classification, sir.
Okay, thank you.
Mr. Taylor, who's your client, sir?
I'm not saying she can't sign one, but
Buckner, 25, 3729, Matthew Kelly on his behalf. I acknowledge that he's got a no bond warrant signed by Judge Lloyd. So just ask that it be moved over to a violation of probation arraignment.
All right, so Mr. Buckner, you are here on violation of probation warrant, sir. Are you going to represent him throughout the course of this case, sir?
Yes, Your Honor.
All right, Mr. Kaler is here on your behalf. I do find probable cause based upon the warrant. You are going to be held at no bond, sir, until you see a judge on May the 11th at 8:30.
have her transfer it over.
Okay, I don't know who's talking, but whoever it is needs to be quiet.
What was that date, Judge?
May the 11th at 8:30.
Thank you, Judge. That's all I have.
Thank you, Mr. Buckner.
So I'm saying,
May 11th. He's-
already
You are
got,
on the phone listening to first appearance. You are to be on mute. Every single one of you, your phone should be on mute. I should not hear any voice whatsoever unless you are the inmate that I am talking to. Or do you have a case on first appearance? Who's your client?
Louis Cruz. Cruz with the C does not mean the
Louis Cruz? Louis Cruz.
Louis Cruz.
Hold on a second, Judge. He's a pro
He's
se.
coming.
He's over there.
We can help you.
Right
Oh
there.
my God, he was
Right here.
talking.
Black line.
All right, Mr. Torna is here on behalf of Mr. Cruz. Have you going to be representing him throughout the entire course of the case? All right, Mr. Cruz, you are here on a violation of probation, sir. I do find probable cause based upon the warrant that I actually signed. Mr. Torna is here on your behalf. You are going to be held no bond, sir, until you see a judge on May the 19th at 12:45. Anything additional, sir?
Not on this case, Your Honor, no.
All right, sir. Thank you so much. All right, thank you, Mr. Cruz.
There was a case Louis Almazan. He's been brought over again today.
He's already been done.
We've taken care of that?
Yep.
Okay, then I have nothing else before.
Almazan.
Thank you.
Thank you, Your Honor.
He went back already?
We already did him. He's been done.
He's been assigned public or assigned to public defender.
We did.
Very good. Thank you, Your Honor.
Jimmy Headley. You can talk again, please. Thank you. Mr. Headley, you are here charged with possession of paraphernalia and possession of methamphetamine. Do you have an attorney, sir?
No, ma'am.
You afford to hire one?
No.
Sir, I will appoint the office of the public defender. I do find probable cause for your two charges. Your bonds are set at $1,000 on the para, $5,000 on the methamphetamine. Your next court date is May 19th at 8:15, sir. Thank you.
Thank you.
Brock Hood. Mr. Hood, you're here charged with possession of paraphernalia, sale of amphetamine, and sale or dispensing drugs without a prescription. Do you have an attorney? Do you
No.
have an attorney? Can you
No.
afford to hire one?
No. Is this a brand new charge or is this something with the old
These are
case?
add-on charges, sir. These are add-on charges. Can you afford to hire an attorney?
Which case are they added on to? Because I have an attorney paid for one case and I have two other cases that I have a public defender for. Can you see which they're
Sir,
representing me
stop
for?
talking. Stop talking.
If he wants public defender, we would need to be appointed on this case. This is a case from August 12th of the year 2025 that is just now coming through the system.
But it does say they're add-on charges, so
I
are
know,
you
he's
all?
got other cases he's in jail on already. He's been in jail since December 31st. But
But
this
were there
incident,
already charges under the case number 26 CF 3672? And has he already been appointed attorney?
I looked at it earlier, I don't think so, because
3672.
just one second. Good.
All right. So, sir, you do not have an attorney on this case. So are you going to hire someone or do you want me to appoint the public defender?
I'd appreciate it if you would appoint a public defender.
And I will appoint the office of the public defender. I do find probable cause for each of the three charges. Your bonds are set at $5,000 on each count. Your next court date is May the 19th, sir, at 8:15. Thank you, sir. Courtney Johnson.
Sanderson Park Defender's Office. I would ask for Mr. Johnson to be released on his own recognizance, would ask to be appointed to this charge. This is a nonviolent charge. He's been found incompetent to proceed in 2026 and then 001227BA, actually on April 13th, 2026. So I would ask for ROR and for office to be appointed on this case.
Was that in a felony or an M8 case?
It's an M8 case. Your Honor just signed an order finding him incompetent on April 13th, 2026, 2 days ago. It's a 2026 MM001227 case.
Any objection, Mr. Matthews?
To him being
Released
released,
on his ROR since he was just found incompetent in my division. I just signed the order.
I'll leave it to the court, Judge. I'm not prepared to stipulate to that, but I'm not going to argue.
All right, Mr. Johnson, I'm going to release you on your recognizance, sir. You're going to come and see me next Thursday. Yeah, April 23rd. I need to see you at 8:30. You need to be there. If you're not there, I'm going to issue a capias for you. Do you understand?
Okay.
Mr. Johnson, I need you to say you understand.
Okay.
All right, I'll see you next Thursday at 8:30, okay?
You know,
Okay.
Mr. Defender.
Yes, public defender's appointed. Mark, no, it's not. Jeffrey Kobla. So you are here, did you have a warrant outstanding from another county? It's for Citrus County. It is a no bond hold. We are going to notify Citrus County that you are in our custody and ask them to come and pick you up. If they do not pick you up by April 22nd at 1 o'clock, sir, we will bring you back to first appearance, okay? Thank you, sir.
Yes, ma'am.
Cedric Ossie. For Ossie, you are here charged with possession of cannabis less than 20 grams of possession of methamphetamine. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your two charges. Your bonds are set at 1,000 on the cannabis, 5,000 on the meth. Your next court date is May the 19th at 8:15, sir. Thank you. Colleen Son?
Afternoon, Your Honor.
And sir, you are here because you failed to appear for arraignment on a criminal mischief charge. The judge in that division issued a capias for your arrest. Do you have an attorney, sir?
I never was charged with that. No, I don't. I think I have it. I don't know.
Sir, answer the question only. Do you have an attorney? Have you hired an attorney in this case?
No,
Can you afford to hire an attorney?
no.
I will appoint the office of the public defender. I do find probable cause. Your bond has been set at $2,500, sir. Your next court date is going to be on May the 1st at 8:30, sir. Thank you.
2000. What was it?
Patrick Spradley. Mr. Spradley, you're here on a warrant at Highlands County, sir. You do have a purge of $1,000. You apparently have some pending charges here in Polk, so I'm not really sure why they even brought you to first appearance today. But you do have a bond, sir, so you can bond on this out of Polk County, okay?
Already bonded out on Polk County.
Oh, well, then that's why. So you can bond on this as well. It's $1,000 bond. If you don't bond, then we'll notify Highlands County and they can come pick you up, okay?
Okay, yeah, okay.
On April 22nd.
I can't hear you, sir. What?
I already posted my bond for this charges here in Polk County.
Right. You have to post the bond on this, or we're gonna tell Highlands County to
Yeah,
come
yeah.
pick you up. If they don't pick you up by the 22nd at 1 o'clock, then we'll bring you back to first appearance.
Yes, ma'am.
Okay, thank you.
Thank you.
Jimmy Welch. Mr. Welch, you're here charged with possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No,
Can you afford to hire one?
no.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds are set at 1,000 on the para, 5,000 on the meth. Your next court date is May 19th at 8:15, sir. Thank you.
Thank you.
Thank you, South County. Have a good afternoon.
No.
State of Florida versus, I beg your pardon? Oh, there we go. State of Florida versus Ruth Baez Encarnacion.
No, I do have a follow-up challenge.
Ma'am, you are here charged with disorderly conduct, and then you have a violation of probation. Do you have an attorney? Do you have an attorney?
No,
Can you afford to hire one?
no.
I will appoint the office of the public defender. Ms. Smith?
It's my understanding this occurred in the house. And there's no, and they argued over chicken wings. There's an argument over chicken wings in the house. That's pretty much what the affidavit says. There's no allegation that any public morals were corrupted. Obviously, it didn't happen outside, and it did not outrage the sense of public decency. And it doesn't say anything about affecting the quiet and peaceful persons who witnessed them. I just don't see the probable cause for this disorderly conduct of an argument over chicken wings in a house.
I agree. They could violate our probation for the use of alcohol, but I don't agree that there's PC for a disorderly conduct here. Mr. Matthews, any argument?
I have only information before me. I do not have reason to believe 24 hours will provide additional substantive information. The state's position is to state that it affected the peace and quiet of the persons who are witnessing our actions sufficiently to call law enforcement. Certainly I understand the court's position.
All right, ma'am, I'm going to find no probable cause for this disorderly conduct, therefore none for the violation of probation. That does not mean that your probation officer cannot file a new violation of probation for the purposes or for the reason that they believe you are under the influence of alcoholic beverages. So you might find yourself right back in the jail again. But for purposes of today, you should be released from custody.
So to clarify, you're finding no PC for the violation of probation as well?
That's correct. So you're,
So argue, just, I understand the court's ruling, but I would argue that there are facts alleged that the officer smelled alcohol on the defendant's breath at the time of arrest.
well, I believe the officer violated her probation based upon the new charge, though, not on, based upon the fact that she had alcohol on her breath. At least that's
The
my
officers
reading of
recall,
it.
I apologize.
That's my understanding based on PC, because it doesn't even say that the officer ever spoke to the probation officer. So he doesn't really even know what the conditions of her probation are. He's basing it on what her parents said. But if he had spoken to the PO and the PO had said, yes, a condition of her probation is no alcohol, then I would have agreed with you, but he didn't.
I would ask, I understand the court's
I
ruling,
can give you
Judge.
24 hours on that if you want it.
No. Hey, be quiet. They nothing funny.
With regard to the conditions of probation and the allegation that she was consuming alcohol, I do think that that information is readily available to present to the court.
All right, so then I'm not going to release you on your own recognizance on the violation of probation, ma'am. Right now, you're going to be held no bond on that. I'm going to give the state 24 hours to see if they can gather additional information. So you're going to come back to first appearance on, no, she's still RR'd on the disorderly, so you can leave the court
She's
date.
going to be in custody though.
She'll be in custody, she need the jail court date for that.
All right, so I'm going to bring you back to first appearance tomorrow to see if the state can get additional information. Okay, so we'll see you tomorrow.
Does she want to call it defender on these, or do we do all?
I pointed the
Okay,
PD.
thank you.
All right, thank you, ma'am.
Thank you.
Lauren Beach.
Ms. Anderson, call defender's
I'm gonna
office.
straight.
Okay, thank you.
Ms. Beach, you're here charged with domestic violence battery. Do you have an attorney
No, ma'am.
or to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. I am going to straight pretrial release you on this case, ma'am. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted contact with the alleged victim, but there is to be no violent contact. Do you understand, ma'am?
Yes, ma'am.
Your next court date will be May the 1st at 8:30, ma'am. Thank you.
Thank you.
Ma'am. Natalie Champion, ma'am, you are here charged with aggravated assault on a law enforcement officer and resisting an officer with violence. Do you have an attorney?
No, ma'am, that's not how it went. The statement's false.
Ma'am, don't
I-
say, ma'am,
Hey.
do not say a word or I'll have you removed from the courtroom. Do you have an attorney?
Yes, ma'am, I have a public defender.
My question is, do you have an attorney now?
Yes, and they're supposed to be here today with me.
Well, have you hired someone?
Yes, I did. I
Who did
have
you
mine. A lady, she was a pink dress. I don't know what her name is, but she went and got me the first time that I came to court, and she asked me my personal questions about if I'm receiving Social Security. I say yes, I'm receiving Social Security. I got proof. I live in
Stop talking.
Orlando.
Stop talking.
Yes,
Does she
ma'am.
have another charge?
Yes, Your Honor, she was in jail in 26 MM 2531. State will be requesting a revocation of.
Does she have an attorney in that case?
She does, she has Pamela Hoffman on that.
Okay. All right, so I'm going to appoint the office of the public defender to represent you in this case as well, ma'am. I do find probable cause for your two charges. Your bonds will be set as follows. On the aggravated assault on a law enforcement officer, it will be set at $15,000. On the resisting an officer with violence, it will be set at $10,000. Your next court date on these two charges will be May the 19th at 8:15. You are out on pretrial release in 26 MM 2531. 2531 or 26? 2531. I am revoking your pretrial release in that case, ma'am. So you're going to be held. The bond shouldn't post it, right? So she can still post the bond. But I can't revoke her bond.
She didn't bond.
I'm gonna revoke your pretrial release in that case as well, ma'am. Your
sorry.
next court date is going to be May 19th on the felony, and whatever your court date was on the misdemeanor, it'll still remain the same. All right, ma'am, thank you. Ciara Clax. Ma'am, you are here on a violation of probation for driving under the influence, and you have a failure to appear for pretrial conference on 2 separate charges. You previously were appointed the public defender on the pretrial cases, so I'm going to appoint the public defender to represent you on your violation of probation. Do you, on the cases that you failed to appear for pretrial on, you do have bonds of $5,000 on each of those per the KPS. You are going to be held no bond on your violation of probation. I do find probable cause on all 3. Your next court date is going to be April 17th on the cases you failed to appear for court on, May 18th on your violation of probation. Thank you, ma'am.
Your Honor, if I
Yes.
may, I also have a note that she has a CF 2683. It appears to be a different case than the one in which she failed to appear. If she's out on bond in that case, they would request.
That's at a party.
Oh, is that Hardy?
Yeah,
Oh, very well. Thank
Yeah.
you.
so I figure I need to leave that to them.
Yes, ma'am.
Right, Tracy Cox. Ms. Cox, you are here charged with criminal mischief, $1,000 or more. Do you have an attorney, ma'am?
No,
Can you afford to hire one?
yes, I can.
All right, we're going to indicate that you're going to hire an attorney, ma'am. I do find probable cause based upon the documentation. Your bond in this case is going to be set at $15,000, ma'am. If you do bond, you will be on pretrial release. This is a felony of the 2nd degree, ma'am. It's been upgraded as a hate crime. So that's why it's the way it is. If you do bond, you will be on pretrial release. Conditions will include you will contact pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. Do you understand, ma'am?
Yes, ma'am.
Your next court date will be May 19th at 8:15. Thank you, ma'am. Tanisha Fowler. Ms. Fowler, you are here charged with giving or selling kratom product to under 21 years of age, which I didn't even know what that was. I had to research it. Do you have an attorney, ma'am?
No,
Do you afford to hire one?
no.
And I will appoint the public defender to represent you. I do find probable cause for the charge, but I am going to straight pretrial release you on this case. Conditions will include you contacting pretrial services in person immediately upon your release, and then you're going to call in every Wednesday, and then you're just going to show up for court as you're required to. Okay, ma'am?
Okay.
And your next court date will be May the 7th at 8:30. Is it going to be in Bartow? Yes. Here in Bartow, okay? Thank you, ma'am.
Okay.
Brittany Gallion Godbold. Ma'am, you are here charged with possession of cannabis less than 20 grams and possession of paraphernalia. Do you have an attorney?
No,
Do you afford to hire one?
no.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds are set at $1,000 on each count. Ma'am, be aware that we do know that you are on active probation out of Leon County, so a violation of probation warrant can come down at any point.
At
So
Leon?
that's out of Leon County is what we show.
No,
Not correct?
that's incorrect. I haven't been in Leon County since 2009.
Well, let me see why we think that. Shows that you're on probation.
There's no way, because I'm here. I've been here. I was just on probation here in January. I got off.
It's a date. Doesn't give a date. It looks like you were put on probation on September the 10th of 2025.
That it wasn't me, because I was not there.
Well, it's on your history, so you want to be careful because it's definitely on your history.
but it's not me. I got on
I don't,
probation.
ma'am, I don't know what to tell you. I mean, I'm just telling you, it's on your history. So you have bonds of $1,000 on each count. Your next court date is May the 1st at 8:30, ma'am. Thank you. Shannon Green. Ms. Green, you are here on a warrant out of Lucy County, St. Lucie County. It is a no bond hold. We are going to notify St. Lucie that you are in our custody and ask them to come and pick you up. If they do not pick you up by April 22nd at 1 o'clock, we're going to bring you back to first appearance. All right, thank you, ma'am. Sabrina Higgins. And you are here because you failed to appear for arraignment on a driving while license suspended or revoked case. Do you have an attorney?
No,
Can you afford to hire one?
no.
I will appoint the office of the public defender. I do find probable cause. Your bond has been set at $500 per the KPS. Your next court date is May 1st at 8:30, sir, or ma'am, excuse me. Thank you.
Thank
Rebecca
you.
Holly. Ms. Holly, you are here on a warrant out of Levy County for violation of probation. It is a no bond hold. We are going to notify Levy that you are in our custody and ask them to come and pick you up. If they do not pick you up by April the 22nd, then we will bring you back, excuse me, to first appearance. You've got
Yes,
April
ma'am.
14th up there.
I'm sorry?
I'm
Oh.
talking to my clerk. I apologize.
Oh.
Thank you, ma'am.
Okay, thank you.
Erica Hornsby. Ms. Hornsby, you are here on a case where you failed to appear for arraignment as well. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause. Your bond is set at $250. Your next court date is going to be on May the 1st at 8:30, ma'am. Thank you. Hatteriti Kit. Ma'am, you are here on violation of probations out of Polk County, and then you also have a hold for Hillsborough County. Do you have an attorney?
No, ma'am, I just left Hillsborough County.
Okay, well, maybe you don't have the, the hold's been taken off. Do you have an attorney in your Polk County cases then?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause based on Judge Harb's warrant. You are going to be held no bond until you see him on May the 11th at 8:30, ma'am. Thank you.
Thank you.
Come on, Ms. Brown. We have a.
Maria Smith.
We have a Hadia Brown.
I beg your pardon?
Hadia Brown.
That is it. Your Honor, Sanderson Appellate Defender's Office. I do have a
I
problem
have her
with
down as a male.
Same here. I do have a probable cause challenge on that because the only information I had was she's going to fail to appear for theft by shoplifting, and it doesn't say whether it's a felony or not, or whether it's
Mr. Brown is a fugitive warrant from Georgia.
right. There is, I don't have any, you have the warrant, because the only information I had in the probable cause affidavit was, it just says it's a failure to appear for theft by shoplifting. It needs, for there to be probable cause on this type of case, there needs to be, at least, it needs to be designated as a felony, and it also needs to say that it's punishable by more than 1 year for extradition to apply, and I don't have that information.
I have nothing. Okay.
I have, the assistant public defender, contacted me for court. What I have is what is before the court. I did attempt to look at the case number that's provided in the warrant, for Fulton County, Georgia. That access to the clerk system there appears to be behind, it is certainly behind a sign-up wall. It may be behind a paywall. I did not create an account to take a look. So it appears that information might be remotely available. It was not provided in the information that I have. I was not immediately able to find it prior to court. I did not have reason to believe I would be able to find that. Subsequently, as I know the court is already aware, it's not a case that flows through my office.
All right, ma'am, I'm gonna release you on your own recognizance on this matter. I think that means that she doesn't even have to have a fugitive hearing, correct?
I think she still has a hearing.
Still has a hearing?
That's my understanding.
All right, so ma'am, you're still gonna have to come back for that hearing on April the 21st at 8:29. So, that'll be here in the courthouse, April 21st at 8:29. Do you understand?
Yes, ma'am.
All right, ma'am,
And
thank
she
you.
can ask for a public defender then if they going forward.
No, no, we're not gonna do that. Kyria Smith? Ms.
Yes.
Smith, you're the charge of possession of paraphernalia, possession of methamphetamine, and petty theft. Do you have an attorney?
No,
You appear to hire one.
no,
And I will appoint the office of the public defender. I do find probable cause for your three charges. Your bonds are as follows: 1,000 on the para, 5,000 on the meth, 1,000 on the petty theft. Your next court date is May 19th at 8:15, ma'am. Thank you.
thank you.
Natalie Vasquez. That interpreter never logged in. Ma'am, you are here charged of possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, no, Your Honor.
Do you afford to hire one?
No, Your Honor.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at 1,000 on the para, 5,000 on the meth. Your next court date is May 19th at 8:15, ma'am. Thank you.
Thank you, Your Honor.
Hi, do we have a Romanian interpreter on the
Oh,
line?
let's sit down. Where is Mr. Varno?
Is there a Romanian interpreter on the line?
Yes, we do. Good afternoon, Your Honor.
All right, and your name, sir?
My name is Chris Hobel. I'm a registered Romanian interpreter.
All right, sir. And if you'll raise your right hand for me? Do you swear to interpret from English to Romanian? Is that the language, Romanian? English to
Yes.
Romanian, Romanian to English to the best of your ability?
I do.
All
And
right.
then again, for the record, my name is Chris Hobel, Hoble, registered Romanian interpreter.
Thank you, sir. And we have Daniel Varna.
Daniel Varna?
Duh.
Yes.
He is charged with fraudulent use of personal identification,
Sunteți acuzat de folosirea fraudulentă a unor mijloace de identificare,
grand theft,
furt major
and then theft of a credit card.
și furt a unei cartele de credit.
Do you have an attorney, sir?
Domnule, aveți un avocat?
Nu.
Nu.
Can you afford to hire one?
Puteți să vă permiteți să vă angajați pe proprie cheltuială un avocat?
Nu.
Nu.
Sir, I will appoint the office of the public defender to represent you.
Domnule, o să desemnez biroul apărătorului public să vă reprezinte.
I do find probable cause based upon the documentation.
Pe baza documentației existente, găsesc că există suspiciune întemeiată.
Your bonds are as follows.
Cauțiunile în cazul dumneavoastră sunt după cum urmează.
On the fraudulent use of personal ID, $5,000.
Pentru folosirea fraudulentă a unui mijloc de identitate, $5.000.
Grand theft, $5,000.
Pentru furt major, $5.000.
Theft of a credit card, $1,000.
Furt a unei cartele de credit, $1.000.
Your next court date for these charges, sir, will be May 5th at 8:15.
Următoarea înfățișare, în cazul dumneavoastră pentru aceste acuzații, este pe data de 5 mai la ora 8 dimineața și 8 și 15 minute.
Sir, I do see that you are subject to a immigration hold.
Domnule, văd aici că sunteți reținut de asemenea în baza unui mandat de reținere din partea autorităților de imigrație, ICE.
I am requesting the clerk of court to prepare a detainer for my signature today.
Voi cere grefierului șef să-mi pregătească un mandat de reținere pe care să-l semnez astăzi.
You will be held no bond pending ICE retrieval.
În așteptarea celor de la ICE care să vină să vă ia.
Thank you, sir.
Vă mulțumesc, domnule.
Thank you, Mr. Hobel.
You're very welcome, Your Honor. Do I need to make an announcement?
No, sir, that was it. Thank you.
Okay, thank you.
Juan Anales.
Where's Juan Anales? We go back. He's approaching.
You. Sir, you are here charged with possession of cannabis less than 20 grams, tampering with physical evidence, possession of paraphernalia, and then you have violation of probations. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges as well as your violations of probation. Your bonds will be as follows: on the possession of cannabis, $1,000, tampering with physical evidence, $5,000, possession of paraphernalia, $1,000. On your violation of probation, sir, you will be held no bond. Your next court date is May 19th at 8:15. Thank you, sir. Victor Andrade Aguilar.
Come on, Victor.
Sir, you are here charged with resisting an officer without violence. Do you have an attorney? Does he need an interpreter?
You did, interpret?
He clearly doesn't understand what's going on.
Yeah, what? Yeah, you need one, Judge.
All right, we're
I,
bring him back tomorrow.
okay.
Samuel Badger. Mr. Badger, you're here charged with possession of cannabis, driving while license suspended or revoked, and possession of paraphernalia. Do you have an attorney?
No.
Do you afford to hire one?
Possibly. I'm not sure, but no, I guess.
Well, if you think you can hire one, I'm going to give you an opportunity to try to hire one.
Could I take the public defender for now?
No, that's not how it works. I'm going to let you try to hire an attorney. If you can't hire one, an arraignment, you can ask for a public defender. I do find probable cause for your 3 charges. Your bonds are as follows: $1,000 on the cannabis, $1,000 on the paraphernalia, $250 on the driving while license suspended. Your next court date is May 1st at 8:30, sir. Thank you.
That way right there, that way. The bell.
Joshua Valiette. Sir, you are here on a violation of probation warrant. Do you have an attorney?
No, ma'am.
You afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause. Your bond is at no bond. Your next court date is May 11th at 8:30. Thank you, sir.
Thank you.
Nazim Bargus. Sir, you are here on violation of probation warrants. Do you have an attorney?
Yes, ma'am.
Who's your attorney?
I'm not sure. I just hired him.
You've hired an attorney, but you don't know who it is?
My father hired him, Your Honor.
All right. Is there anyone on the line representing Mr. Barguthi? All right. Well, they are not present today. Do you want to go forward without your attorney?
No, ma'am. Yes, ma'am.
Okay. We'll go forward without your attorney. I do find probable cause based upon the warrant signed by Judge Harb. You are going to be held no bond and see a judge on May the 11th at 8:30, sir. Thank you.
Thank you.
Robert Riddle.
Yes, ma'am.
Riddle, you're here charged with petty theft of a merchant. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $5,000. Your next court date is May the 19th at 8:15, sir. Thank you. Bobby Brown.
Yes, ma'am.
Mr. Brown, you're here charged with misuse of 911. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause. Your bond is set at $1,000. Your next court date is May 1st at 8:30, sir. Thank you.
Okay, thank you.
Isaac Castro.
Yes, ma'am.
Castro, you're here charged with battery. Do you have an attorney?
No, ma'am.
You afford to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is going to be set at $5,000, sir. If you do bond, you are going to be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, her home, vehicle, place of employment, and or school at all times. Were the two of you living together?
No.
I can't hear you.
No, ma'am.
All right, sir. Your next court date will be May the 1st at 8:30, sir. Thank you.
Thank you.
Todd Chisco,
Sanderson Appellate Defender's Office. I do a stipulation with the state that there's no probable cause and he should be released on his own recognizance on the misdemeanor charge of possession of drug paraphernalia as it is subsumed in the higher charge.
all right. Sir, you're here charged with manufacture or delivering narcotic paraphernalia and then possession of drug paraphernalia. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for the manufacture or deliver narcotic paraphernalia. I do not find probable cause for the possession of paraphernalia. On that count, you will be ROR'd. On the higher charge, sir, the bond is $5,000. Your next court date is May 19th at 8:15, sir. Thank you.
Good.
Joshua Christmas.
Yes, ma'am.
Sir, you are here on violations of probation. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for your violations based upon the warrant signed by Judge Harb. You will be held no bond, sir, until you see a judge on May the 11th at 8:30. Thank you, sir.
Yes, ma'am.
James Freenan,
Yes.
you are here charged with driving under the influence and refusal to submit to a breath test. Do you have an attorney?
No.
Can you afford to hire one?
Yes.
All right, sir, we'll indicate you're going to hire an attorney. I do find probable cause for your charges. On your DUI, your bond will be set at $2,500. On the refusal, it will be $1,000. Your next court date will be May 1st at 8:30, sir. Thank you.
Thank you.
Robert DeShomes,
Yes, ma'am.
sir, you are here charged with possession of paraphernalia and possession of meth. Do you have an attorney?
Oh, no, ma'am.
You afford to hire one.
Yes, ma'am.
All right, we'll indicate you're going to hire an attorney, sir. I do find probable cause for your two charges. Your bonds are set at $1,000 on the para, $5,000 on the meth. Your next court date is May 19th at 8:15, sir. Thank you.
Should I get a public defender up?
Hero Etienne,
She said next court, May 19th.
Etienne, you are here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
You afford to hire one.
Yes, ma'am.
Sir, will indicate you're going to hire an attorney. I do find probable cause for your charge. Your bond is set at $5,000, sir. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then every every Wednesday, you will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim's home, vehicle, place of employment, and or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand, sir?
Yes, ma'am.
Sir, your next court date will be May the 1st at 8:30. Thank you, sir.
Thank you.
Jasmine Fielder,
Yes, ma'am. Jermaine Fielder.
sir, you are here charged with resisting an officer without violence and domestic violence battery with a prior conviction. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for your charges. Your bonds,
Sanderson Appellate Defender's Office. I'm looking at the victim comment sheet. It indicates that the alleged victim does want to have contact with him. And I would ask for that.
yes, ma'am.
Thank you.
Your bonds are as follows: 1,000 on the resisting, 5,000 on the domestic violence battery with a prior conviction. If you bond, you will be on pretrial release, sir. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted to have contact with the alleged victim, but there is to be no violent contact. Do you understand, sir?
Yes, ma'am, I do.
All right, sir, your next court date is May 19th at 8:15. Thank you, sir.
Yes, ma'am.
Jervion Fields. Mr. Fields, you're here charged with driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I am going to straight pretrial release you on this case, sir. Conditions will include you contacting pretrial services in person immediately upon your release and then calling in every Wednesday. You will not drive without a valid driver's license. Do you understand, sir?
Yes, ma'am.
So your next court date is going to be on May 4th at 8:30, sir. Thank you.
Thank you.
Sean Giles.
Senator Smith, on behalf of Mr. Giles, he was here yesterday for these same charges, and our office was just appointed yesterday to all these charges. I would ask that his PADC court date remain on April 21st at 9:30, because that's what was discussed in court yesterday on these charges.
Why was he brought back?
I don't know.
I don't know. Okay.
It was in the comments.
All right. So Mr. Giles, apparently they forgot to address your violation of probation yesterday. That's the best I can understand. You were previously appointed the office of the public defender. You are going to be held at a no bond. I do find probable cause. Your court date is going to remain April the 21st, sir, at 8:30 in the morning. Okay, sir? Thank you.
Thank you.
Yes, sir. Ricardo Gomez.
Yes, ma'am.
Gomez, you are here on violation of probations. Do you have an attorney
No, ma'am.
or to hire one?
Yes, ma'am.
Sir, will indicate you're going to hire an attorney. I do find probable cause based upon the documentation. You are going to remain at a no bond, sir, until you see a judge on May the 11th at 8:30, sir. Thank you.
All right, thank you.
Martin Harless.
Yes, ma'am.
Sir, you are here charged with possession of cannabis less than 20 grams, possession of paraphernalia, and possession of meth. Do you have an attorney?
No, ma'am.
You afford to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds are set at 1,000 on the cannabis, 1,000 on the para, 5,000 on the methamphetamine. Your next court date is May 19th at 8:15, sir. Thank you. Mark Johnson.
Ma'am.
Johnson, you're here charged with possession of paraphernalia and possession of cannabis resin. Do you have an attorney, sir?
No, ma'am.
You afford to hire one?
Ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your two charges. Your bonds are set at 1,000 on the para, 5,000 on the resin. Your next court date is May the 19th at 8:15, sir. Thank you. Jordan Jones.
Yes, ma'am.
Mr. Jones, you are here because you failed to appear for your pretrial conference on 3 separate charges. You've previously been appointed the office of the public defender. I do find probable cause based upon the capias. Your bonds have been set at $2,000 on each of the 3 charges. Your next court date will be May 13th at 8:30, sir. Thank you.
Yes, ma'am.
Thomas Latham. Sir, you are here charged with possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
You afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your 2 charges. Your bonds are set at 1,000 on the para, 5,000 on the meth. Your next court date is May the 19th at 8:15, sir. Thank you. Jeremiah Lattimore.
Senator Smith, let defender's
Yes, ma'am.
office. Paul Price challenge on his 2 drug charges.
All right, sir, you are here charged with carrying a concealed firearm, possession of cannabis over 20 grams, possession of paraphernalia, and use or display of a firearm during a felony. Do you have an attorney?
No, ma'am.
You afford to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. Ms. Smith?
Yes, Your Honor, regarding the 2 charges, the cannabis over 20 grams and paraphernalia, I mean, although they did say that it was tested with the AP4 test kit, tested positive for cannabis, they don't have the language that I'm usually accustomed to seeing of that there was a THC greater than 0.03%. I would also point out there's no allegation that it's over what the amount of grams are as well in the affidavit. They just said they found probable cause to charge him with over 20 grams. And they say that, but they don't say that they weighed it and how much the actual weight was for the grams as well. So I have another probable cause challenge on that as well.
Mr. Matthews?
There is an amended affidavit that contains the language regarding the testing and the finding of THC above the legal threshold. I believe I distributed that electronically in copies. This is from the defender. Again, I had a number of those this morning. If not, I have my copy. I'd be happy to show defense counsel an approach with it for.
I don't recall getting an email on that. If I could.
It is possible that I ever looked at, but the amended language is in a different type font. Okay, and I may have, I meant to, it may have been as an additional document in SOMA as well, so I may.
I see that. I still have the challenge though regarding the 20 grams, it being a felony as opposed to misdemeanor with
Because of, you're saying why? Because it wasn't packaged or anything?
No, it's because they didn't weigh it. I mean,
I
they
see
didn't
what you're
put, they didn't put down it's like 20.2 grams or 21 grams. They just say they're charging him with that, but they don't put in the affidavit how they came to that conclusion that it's over 20 grams. So I still have a challenge on the felony aspect of it now.
All right. Well, the court is going to find probable cause today for the carrying concealed firearm, for the possession of paraphernalia, but we're going to come back tomorrow for the possession of cannabis over 20 grams and for the use or display of a firearm during a felony. So,
What was it with the court?
yeah, but that's the only felony is the possession of
Oh, good
cannabis over
point.
20
Okay.
grams. So,
Oh, thank you. So that makes sense. So we would be coming back to tomorrow on that and the 20 grams.
correct. So on the carrying concealed firearm, sir, I'm going to set your bond at $5,000. On the possession of paraphernalia, it's set at $1,000. You do have a presumptive bond of $5,000 on the possession of cannabis over 20 grams, but I'm not going to set a presumptive bond on the use or display unless you want me to.
I would ask.
Yes, ma'am.
Okay.
I would ask for a provisional bond in case he wanted to bond out today and not wait till
Yeah.
tomorrow.
All right, then I'm going to set the bond at $15,000, sir. If you
Your
do
Honor.
bond, you are
Yes,
going to
ma'am.
be on pretrial release. Conditions will include you
Your Honor.
contacting pretrial services in person. You will also be fitted with a GPS monitor prior to being released from custody. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You
Yes,
will be
ma'am.
subjected to random
Yes, ma'am.
urinalysis at your own self-pay.
Your Honor, I didn't see that he had any prior record. Does he have a juvenile history? He's 19 years old.
I don't know, but he's carrying weapons around. I mean, he had something, I think he had something at 17, so yeah, he did, I think he did have something.
Yes, ma'am, I did. I didn't have nothing until I was 15.
You need to stop talking, okay, because you're gonna
Yes,
hurt
ma'am.
yourself. Don't say anything, okay? So anyway, so I'm gonna put him on pretrial release with those conditions. Sir, if you do bond, your next court date is going to be on May the 19th at 8:15.
Yes, ma'am.
Yes, I appointed the public defender. All right, if you don't bond today, you're gonna come back to court tomorrow on those two charges, okay?
Yes, ma'am.
All right, sir, thank you.
You're welcome.
Yeah.
And then Wednesdays.
Call on Wednesdays, yeah. All right, Carlos Macalon. So
Yes,
you
ma'am.
are here charged with driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
So I will appoint the office of the public defender. I do find probable cause. Your bond is set at $250. You also have a writ of bodily attachment for child support, sir. That is a $1,000 purge. On the criminal charge, your next court date is May the 1st at 8:30. On the purge, you have to post the purge, $1,000, okay? Thank you,
Okay.
sir. Joseph McCreary,
Sanderson Flood Defender's
I'm gonna
Office.
straight
What did and what's that contact?
and I'm gonna straight pre-trial.
Thank you.
Sir, you're here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. I'm gonna straight pretrial release you today, sir. Conditions
sir.
will include you contacting pretrial services in person immediately upon your release and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted contact with the alleged victim, but there is to be no violent contact. You understand, sir?
Yes, ma'am.
Sir, your next court date will be May the 7th at 8:30, sir. Thank you. Trent Newton.
Sanderson Flood Defender's Office. I have a stipulation from the state that there's no probable cause on the driving license been revoked, second conviction or any driving charge. He should be ROR'd on that. As the officer did not see him driving.
Okay. All right, so sir, you're here charged with domestic violence battery with a prior conviction and driving while license suspended or revoked as a second conviction. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for the domestic violence battery with a prior conviction. I will not find probable cause for the driving while license suspended as a prior conviction. On that count, sir, you will be released on your own recognizance. On the domestic violence with a prior conviction, your bond will be set at $7,500. If you do bond, you will be on pretrial release, sir. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. You understand, sir?
Yes, ma'am.
Next court date is May the 19th at 8:15, sir. Thank you. Jason Peralta,
Yes, ma'am.
so you are here on violation of probation. Do you have an attorney?
Yes, ma'am.
Who is your attorney? Oh, you have John Legore. Are you expecting him to be here today?
Oh, I don't think so.
Okay, you want to go forward without him?
Yes, ma'am.
All right, sir, I do find probable cause based upon the warrant issued by Judge Harb. You are going to remain at a no bond hold, sir, until you see a judge on May the 4th at 8:30, sir. Thank you.
Yes, ma'am.
Ernest Pinkney. Mr. Pinkney, you are here in violation of probation, sir. Do you have an attorney?
No,
You afford to hire one?
no,
Sir, I will appoint the office of the public defender. I do find probable cause. You're going to remain at a no bond until you see a judge on May the 11th at 8:30, sir. Thank you. Christopher Pravat.
Yes, ma'am.
Pravat, you're here charged with domestic violence battery with a prior conviction, possession of cannabis resin, and possession of paraphernalia. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for each of your 3 charges. Your bonds are as follows. On the domestic violence battery prior conviction, $7,500. Possession of cannabis resin, $5,000. Paraphernalia, $1,000. If you bond, you will be on pretrial release. Conditions will include contacting pretrial services in person immediately upon your release, and then every Wednesday, only on the DV. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, her home, vehicle, place of employment, and/or school at all times. Were the 2 of you living together?
No, ma'am.
Sir, your next court date is May 19th at 8:15. Thank you, sir. Anthony Ratley. Sir, you are here charged with trespass. Do you have an attorney?
No, ma'am.
You afford to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $1,000. Your next court date is May 1st at 8:30. Thank you, sir.
Thank you, ma'am.
Carlos Rivera,
Yes, ma'am.
or you are here charged with following, harassing, or cyber stalking a person with a credible threat. Do you have an attorney?
Yes, I do. David Kaler Logger.
All right, were you expecting, well, Mr. Kaler was here earlier, Matt Kaler. Were you expecting Mr. Kaler to be here today?
As soon as if I'm eligible for bond, ma'am, I will be going to their office.
Okay, so you have not hired them yet.
I have not had a chance to hire, ma'am, no.
All right, so we'll indicate you're going to hire a private attorney, sir. I have reviewed the paperwork and I do find probable cause for the charge. Your bond is going to be set at $10,000, sir. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Wednesday. You are going to be placed on GPS monitor, sir, prior to being released from custody. You will not possess any weapons, firearms, ammunition, or knives. You will have absolutely no contact with the victim identified in this case. You will stay 500 foot away from the victim, her home, vehicle, place of employment, and/or school at all times. Do you understand, sir?
Yes, ma'am.
Your next court date is May 19th at 8:15, sir. Thank you. David Rivera. Sir, you are here charged with possession or displaying a canceled or revoked driver's license and threat of death or serious bodily injury to law enforcement. Do you have an attorney?
No, ma'am, I do not.
Can you afford to hire one?
Unfortunately, I cannot at this time.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds are set at $250 on the possession of a canceled or revoked license, $1,000 on the threat of death or serious bodily injury. Your next court date is May 1st at 8:30, sir. Thank you. Esteban Salama.
Yes,
Sir,
ma'am.
you are here charged with driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
You afford to hire one?
No, ma'am.
Sir, excuse me, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $250. Your next court date is May 1st at 8:30, sir. Thank you. Dwayne Stackhouse.
Senior Smith Defender's Office. The alleged victim wants to have contact with him, so he's gonna ask for no violent contact.
Mr. Stackhouse, you are here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
You afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is going to be set at $5,000, sir. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday you will call in. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted contact with the alleged victim, but there is to be no violent contact. Do you understand, sir?
Yes, ma'am.
Your next court date is May the 1st at 8:30, sir. Thank you.
Thank you.
Carl Stewart.
Ma'am.
Stewart, you are here charged with felony petty theft and resisting an officer without violence. Do you have an attorney?
I have a public defender right now, ma'am.
Oh, you do have a public defender. All right, sir. I see that. I apologize. I do find probable cause. These are add-on charges. Your bonds will be set as follows: $5,000 on the petty theft, $1,000 on the resisting. You were previously placed on pretrial release, sir. You will be on pretrial release on these charges as well. Conditions that were placed were no contact with the victim, and you will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. Your next court date is May the 12th at 8:15, sir. Thank you. Dylan Tarleton.
Sanderson Defender's Office has to be appointed on his case. This is a nonviolent misdemeanor trespass, nonviolent crime of trespass. I would ask for ROR. He has been found incompetent to proceed in 2025 MM 007533BA on February 23rd in 2026.
All right, Mr. Tarleton, I'm going to release you on your own recognizance, appoint the public defender's office, and I'm going to set you to come see me next Thursday, April 23rd at 8:30, okay? So I want to see you next Thursday. Do you understand?
Yes,
You have
ma'am.
to say, yes, all right, I'll see you next week. Thank you. David Taylor,
Yes, ma'am.
sir, you are here on violation of probations. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
Not at this moment.
Sir, I will appoint the office of the public defender. I do find probable cause based upon the warrant signed by Judge Hill. You will be held no bond until you see a judge on May the 11th at 8:30, sir. Thank you.
Thank you, ma'am.
Timothy Trawler. Sir, you are here charged with possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your two charges. Your bonds are set at $1,000 on the para, $5,000 on the met. Your next court date is May 19th at 8:15. Thank you, sir. Jason Wolfgram,
Yes, ma'am.
we're here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Look forward to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your for your charge. Your bond is set at $5,000, sir. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then every Wednesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, her home, vehicle, place of employment, and/or school at all times. Did the two of you live together, sir?
Yes, ma'am, we're married.
Okay, well, I'll give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand, sir?
I didn't hear that. What'd you say? What'd you say, ma'am?
You get one opportunity within 48 hours of your release from custody with a law enforcement escort to go back to the home to get your personal belongings. Do you understand?
Yes.
Next court date is May 1st at 8:30. Thank you, sir. Enon Woodsonk,
Yes, ma'am.
Benjamin Woodsonk Enon.
Yes, Your Honor.
Correct? Okay. So
Yes,
you
Your
are here
Honor.
because you failed to appear for arraignment. Do you have an attorney?
No, Your Honor.
Can you afford to hire one?
No, Your Honor.
Sir, I will appoint the office of the public defender. I do find probable cause based upon the capias. The judge who issued the capias set your bond at $1,000, sir. Your next court date is going to be on May the 1st at 8:30, sir. Thank you. Thank you, guys at Central. Have a good afternoon.
All right, thank you too, Judge. See you tomorrow.
Yes, sir. All right, guys, thank you.
Thank you, Judge. Hi.
Yes.
You called on me earlier during court and I had a minute.
Oh.
And I apologize. I didn't mean to disrespect.
Oh, no,
trying
that's
to
okay.
Talk around it, but I was caught off guard.
That's
So I
okay.
apologize for that.
No problem.
Red-handed with a minute.
Yeah, it was.
All right, so we can get started. Attorney Dean, are you with us?
Hi, good morning.
Good morning. So good morning, I'm Parole Officer Casello, and I'm hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Christopher Norton, inmate number 2302222. Today is Wednesday, April 15th, 2026. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Christopher Daniel Norton, 230222.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, good morning. Hannah Dean on behalf of Mr. Norton.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Parole Officer Christina Schaefer.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause believed to be committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred to by the Department of Corrections for diversion for substance abuse programming and treatment. If at the end of this hearing I determine you should be held in prison pending further proceedings, I'll provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Norton and Officer Schaefer, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. We're going to go over the procedure for today's hearing. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. After the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
Who, me?
Yep.
No.
Yes, you meant no? Okay. So we're going to go over your rights for today's hearing. So first thing, your first right is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
Perfect. So we are now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying the charge. So Officer Schaefer, can you please review the charge for us?
Charge 1, drugs. On 10/15/25, you tested positive for cocaine and signed a voluntary admission form. On December 30th, 2025, you tested positive for cocaine but denied use. The sample was sent to Premier Biotech Labs and confirmed positive. On February 17th, 26, you tested positive for cocaine and admitted to crack use. You signed a voluntary admission form. On March 2nd, 26, you tested positive for cocaine with your REACH program that you reside in. On March 4th, 26, you tested positive for cocaine and fentanyl. You denied use and the sample was sent to Premier Biotech Labs.
Thank you. You've also submitted evidence in support of the charge. Can you please identify the evidence for us?
Going down, starting with Exhibit A, you want to hear?
Yes. Yes,
Okay,
please.
Exhibit A, remand to custody order. Exhibit B, parole conditions. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, State of Connecticut BOPP decision information summary. Exhibit F, Connecticut BOPP preliminary hearing summary. Exhibit G, Premier Biotech Lab final reports December 30th, 2025, February 17th, 2026, March 4th, 2026 that was received. Exhibit H, misconduct dated 10/15/25 and 2/17/26. Exhibit I, voluntary admission forms 10/15/25 and 2/17/26. Exhibit J, the connection REACH positive drug screen documentation. Exhibit K, timeout compliance discharge report.
Thank you. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have.
Thank you. I did not receive anything from the defense at this time. Do you need time to submit any documents?
Not at this time. Thank you.
There are no witnesses for today's hearing. So at this time, it is the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Schaefer, any comments at this time?
Just wanted to note that Mr. Norton did have a mixture of some voluntary admissions to his drug use and at other times denial. Those denials of drug use did result in positive lab screens confirmed from Premier Biotech Labs. It appeared Mr. Norton was not readily willing to admit that he had a substance use problem, which led parole to seek higher level of care. Unfortunately, out in the community, that wasn't possible, leading us to the timeout placement.
Thank you.
Yeah.
And counsel?
Thank you so much. I do just have a couple of very brief questions. I would just start, P.O. Schaefer, can you just explain when the referral was attempted for Apt Foundation, what was the reasoning that they had stated that he was unable to participate?
So Mr. Norton was taking the Sublocade injection at that time. And the day before he was going to Apt, I physically brought him myself to his program to get that Sublocade shot. And apparently he left the program without receiving the shot. That in addition to the fact that Apt, I guess, doesn't support the Sublocade shot. I'm not sure exactly their reasoning, but that's a substance that they don't support is what I was told. And then also he has some significant disabilities they were concerned with.
Thank you. I will just note for the record, I did, speak with Apt, and my understanding is that they did have all the different types of at least in their residential program as of now. I'm not saying, a couple months ago when you had called, but it sounds like they do now have the ability to handle Sublocade, Suboxone, and methadone at this point. But I would just note, my client also, I believe, was told, for IOP at Wheeler Clinic that he was not being recommended to a higher level of care. My understanding from speaking with him is that he had, gone out into the community and spoken with Wellmore to see if they could put him into IOP, because he, I think, was trying his best to get this under control and to comply. I will just note that for the record. In addition, I would indicate that my client is already at this point participating in the TOP program. So we're certainly on board with that. But I did just want to make those notes. And then I would just argue that the allegations aren't serious enough to warrant revocation. But we aren't contesting the TOP program. Thank you.
Thank you. Any further comments from either side before I do announce my findings?
I just did want to comment on the Wheeler Clinic component. So I had been in communication with them asking for him to be returned to IOP, which is, intensive outpatient program, so that he could stay in the community. They also did not want to make that recommendation. their concerns were some cognitive limitations to the group. Also, his ability to be compliant with attendance while in the program was really not up to par. In one of the reports from Wheeler Clinic, he had so many absences, he had to stay later in the program. I think he had about 5 absences from the group. So that's pretty excessive. Leading us, again, one of the reasons, non-compliance for his IOP, missing so many sessions, getting him an inpatient where he has the ability to be there and do the program and not worry about getting there and stuff like that. So we tried to work our way up, the least possible to start with, which is keeping him in the community with IOP, leading us to an inpatient recommendation and ultimately timeout. That's all.
Thank you.
I speak.
Yes, Mr. Norton, if you would like to say something, you can say something at this point.
For one, if I missed 5 classes in Wilmore, they would have kicked me out. You couldn't allow me to miss 3 classes at any time. You would have dismissed me out of the program. Even for myself, okay, they would have said, listen, Mr. Norton, you missed too many classes. For any of our classes, you only missed 3. Not 5, because 5 is way too much to even be in Wilmore. They would have kicked me out long ago.
Wheeler
So
Clinic?
yes, you can't miss 5. The thing is that when I went to a different group, they said that I'm doing good in another group, that I shouldn't be stepped back up to where I have to step back to another program. So to help you out, I went to another whole place called Wilmore. I went to Wilmore, I talked to Lisa, I think her name's Lisa, the young lady that's the counselor down there. And I got my daughter into the same program because she's in the shelter. So she needed help. So I got her there, and me and her started the program to do IOP. I was supposed to start IOP. She said I could always do IOP after I got out of my other class. It would start at 12. So I was like, that's great, because I can take the bus right from Willard, right down the street downtown where they have the classes at Wilmore. And I can start the classes at 12 o'clock, she said. So that's where I was going to start on last Thursday, last month.
Thank you. I appreciate you putting that on the record. Thank you.
Yep. Thank you for that. Unfortunately, I never received any documentation that any of that had been initiated.
Thank you. Before I do announce my findings, anything additional, Council Officer Schaefer?
No, thank you.
So I have listened to the testimony today, and I am going to announce my findings now. So on charge number 1, the condition of drugs, Mr. Norton, I am going to find probable cause based on the evidence presented in State's Exhibits B, C, G, H, I, and J. I'm also do find that the act is serious enough to warrant revocation. So what happens next is we're going to jump into the diversion eligibility, since you were referred for the diversion program. So what that means, Mr. Norton, is that if you wish to participate and apply, and I find that you meet the eligibility criteria, I'll continue your case while you are provided the opportunity to participate in that program and while at the correctional facility. What happens is that if you successfully complete the program and treatment provided, I'll dismiss your case and order your parole reinstated. If you do not complete the program and treatment, the board will then schedule and convene a revocation hearing to determine whether you have violated the conditions of your parole. And if so, at that time, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So Mr. Norton, I do want you to know that participating in the diversion program is completely voluntary. So do you understand the diversion process if you wish to apply for it?
Which program is that, ma'am?
That's the top program.
This is the one that you're already participating in at the jail.
Yeah.
Because a lot of programs right now are being held back because there was 3 ODs, 2 fights, 1 stabbing, and we're doing so much electricity. So we're supposed to be in groups a lot of times, and they're backing up the groups. Does that count against me? Because since I've been here, I haven't been to an NA meeting or anything else.
No, this is the top, Mr. Norton, this is.
Because this place has more drugs.
Mr. Norton, your attorney's trying to just.
Mr. Norton, This is for the top program. These are the substance use classes. I think you've been doing it like basically every day that you go to for a couple hours. It's like treatment. That's what the program you would be doing is. And this is what we had discussed. If you complete this program, then you would be reinstated automatically as long as you don't get any DRs. Do you still want to go forward with that?
Yes. I do.
Okay, thank you.
So I'm gonna announce my findings with respect to your eligibility for the diversion process. So I am finding that you have no pending misdemeanor charges or felonies. I'm also finding that your discharge date is more than 60 business days from the date of remand to actual custody. I also find that there's evidence that you have identified substance abuse treatment needs. And I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of your parole. In addition, I'm also finding that there's some evidence that you received or were provided an opportunity to receive substance abuse programming or treatment during a period of parole supervision in the community. So with that, Mr. Norton, I am finding that you are eligible for that program in the facility. Before I accept your application, I just need you to indicate whether or not you understand the following statements by stating yes or no. So the first one is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
Thank you. I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
And lastly, I understand that the participation in this process is completely voluntary.
Yes.
Perfect. So I am going to accept your application for the diversion program, Mr. Norton. So continue with that treatment and we'll be notified once you are completed to reinstate your parole, okay?
I ask you guys something, please, on regular. You put us in here, like we're on like a level 1 or whatever. And I'm in here with some people that are just never going home. So half of us are. So why would I be in with a killer or
Mr. Norton, Mr. Norton, I understand what you're saying, but parole doesn't have control over that. That's all done just through the Department of Corrections and their own like internal classification system. Like parole themselves don't have control over where to my understanding, where the clients, like the facility that they're placed at, just so you know. But I can set up a call with you so that we can discuss this and, see if there's anything we can do. Okay.
Thank you.
No problem.
So this does conclude the preliminary for Christopher Norton, inmate number 230222. Good luck to you, Mr. Norton.
Thank you, Matt. Have a good day.
Thank you.
Good luck.
Thank you.
Thank you.
Take care.
Bye-bye.
I can be dispensed, right?
Yes, you
You're all
can
set.
let the officer know and they'll get the next person. Thank you.
Thank you.
Yeah, we're ready for the next person. I'm looking for a snake. Shut up, it's hungry.
Good morning, Officer Dividler.
Good morning.
So we will get started, Mr. Ellison. So good morning, I'm Parole Officer Costello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Colby Ellison, inmate number 399768. Today is Wednesday, April 15, 2026.
The wrong inmate number.
Surprise. What's your real inmate number?
419801.
It is. I'm sorry about that. Thank you for correcting me. I appreciate it. So this is a revocation hearing concerning Colby Ellison, inmate number 419801. Today is Wednesday, April 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number again for the record?
Colby Ellison, 419801.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Deed on behalf of Mr. Ellison.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Parole Officer DeVilder, Hartford Special Management Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state and you has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Ellison, Albert Dividler, can you please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I swear.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I do not.
So we will go over your rights for today's hearing. So first, you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do, and I am.
So you're now going to review the charges that the state, your parole officer is bringing against you, and the information underlying each charge. Officer DeViley, can you please review the charges for us, starting with number 1, restriction on pornography?
Charge number 1, restriction on pornography. On 2/3/2026, IPPC Enhanced Internet and Monitoring Software was installed on your phone. On 2/9/2026, your supervising officer conducted a review of this software where you were found to have accessed and viewed pornography and sexually stimulating content on 2/7/2026. Per your condition, restriction on pornography, at no time are you to access or view this material. Charge number 2, problem sexual behavior treatment. On 1/28/2026, you completed your intake with the Center for the Treatment of Problem Sexual Behavior and signed your treatment agreement. Per your treatment agreement, you are not to engage in social media chats. A review of your enhanced internet and device monitoring revealed that you had downloaded the Patreon and Crunchyroll app, set up a profile, and entered chats. The same review of IPPC monitoring conducted on 2/9/2026 yielded results of you viewing sexually stimulating material on your cell phone. At no time were you given permission by CTPSB staff or your supervising officer to view sexually stimulating material, which violates your treatment agreement. You were unsuccessfully discharged from sex offender treatment.
Thank you. And the evidence submitted by the state was already identified at the preliminary hearing, and that one does remain the same. Counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation for and all the other documents identified for today?
Yes, we have. Thank you.
And I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement, and exhibit 2, a support letter from Alexandra Fritz. Counsel, do you need time to submit any other documents?
We do not. Thank you.
Don't have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Zavada, any comments at this point towards the charges?
Yeah, I just want to reiterate that, Mr. Ellison had just served a 9-month sanction for a technical violation for the same exact behaviors. And within 3 days of getting the IPPC monitoring installed on his software, he knowingly looked at material he's not supposed to be looking at. So this is just very concerning. Thank you.
Counsel?
Yes, thank you. I would just renew my comments and arguments that were put onto the record at the preliminary hearing, and would just again note that based on my review of the parole regulations and statutes, I didn't see the term pornography or sexually stimulating material defined, which I do think deserves some consideration, but no additional comments. Thank you.
Thank you.
I would just like to comment on Ms. Dean's comment. When I confronted Colby about these actions on the IPPC monitoring, he did admit that he looked at these things knowing it was wrong. So that just kind of illustrates that he knew he wasn't supposed to be doing that. Thank you.
Yeah. Council, anything further?
Nothing further. Thank you.
Just take a quick moment, announce the findings. So on charge number one, so I have listened to the testimony today as well as what was put on the record at the preliminary hearing. I reviewed all the evidence submitted. So with that, Mr. Ellison, on charge number one, I am finding that you violated the condition of restriction on pornography based on the evidence presented in states exhibits B, D, F, and G. And on charge number two, I'm also finding that you violated the conditions of problem sexual behavior treatment based on the evidence presented in states exhibits B, D, E, F, and G. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. Once the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So Officer DeValer, any statements towards Mr. Ellison's background and history?
I just want to state that Mr. Ellison has had both inpatient and outpatient problem sexual behavior treatment. We've installed the device monitoring. We have, pros supervising him, and it just doesn't seem to be deterring these behaviors. So we are requesting a full revocation at this time.
Thank you. And counsel?
Yes, thank you. My client, Mr. Ellison's 30 years old. He was born in Germany, but raised in Connecticut. His greatest support in the community are his aunts. He did unfortunately lose his mother in 2024, which has been very difficult. Most recently, he utilized Cheney House while he was on supervision. Previously, he has successfully completed January Center. He did also participate in the REACH program previously in Hartford, and also previously successfully completed Open Hearth in Hartford. He does have work experience while on supervision, including Wendy's, Trader Joe's Warehouse, 7-Eleven, BJ's, Shake Shack, and Teriyaki Madness. Most recently, he was reportedly scheduled to begin the CTPSB group. Before he was on supervision, he was participating in individual therapy at CRT. He is currently compliant on the Connecticut SO registry. He meets while in the facility with a mental health worker once every other week at Osborne Correctional. He is medication compliant. He would like, if possible, to go to a halfway house in Hartford. He, I know, is hoping in the future to utilize the REACH program once again. My client is hoping to obtain a position in a bakery, but is open to any sort of opportunities that are offered for jobs. He's also open to any treatment being recommended, including doing the CTPSB program and also getting back to individual therapy. And lastly, he is, I know, hoping to obtain his driver's license in the future. I'm asking that you would consider reparoling my client prior to his EOS date later this year. As we noted, he really is somewhat limited on the support that he has in the community. He did, unfortunately, as I stated, lose his mom, who was his biggest support, and he will very much need assistance with housing while in the community. Parole, I think, could certainly be of assistance to him in getting back on his feet, just to get some sort of, housing assistance, because later this year he EOSs and he won't have any supervision. So I know that he could certainly benefit from the services parole provides. Thank you.
Thank you. Just gonna take a moment and then I'll announce my recommendation. So have listened to today's hearing and I've reviewed all the evidence as well stated before. With that, I do just want to note on the records that this is Mr. Ellison's third violation on supervision. He was only out in the community for 18 days between his last re-release and remand to custody. And as Officer DeBreiler stated on the record, the behavior is the same as his last violation. So the behavior hasn't changed for Mr. Ellison, his behavior. So with that, Mr. Ellison, I am going to recommend that your parole be revoked and that you have no new re-parole date. That's an approximate 10-month period of confinement as a sanction. In the event the board does decide to lessen my recommendation, I'm going to recommend the following conditions: a mental health treatment, enhanced internet and device monitoring, no contact with minors, problem sexual behavior treatment, restriction on pornography, and halfway house placement. So what happens next, Mr. Ellison, is that my recommendation is going to go to the board next week on April 23rd. On that day, the board can only do two things. They can lessen my recommendation if they choose to do so. And if for any reason they would want to, or that's it, or they can adopt the recommendation, which means that you'll stay until your end of special parole sentence. So you'll be notified with their decision about a week or so after that hearing date with what they've decided, okay?
Okay.
Colby, if you want to call our office on that day, either myself or one of the secretaries can let you know what the decision was.
Okay. And you said it was the 23rd next week? Or
Yes,
27th?
that's right. The 23rd, the Thursday. Mhm.
Okay.
The revocation hearing for Colby Ellison, inmate number 419801. Good luck to Mr. Ellison. Thank you, officers of Butler.
Thank you. Good luck.
Thank you.
Thank you, everyone.
Yeah. Good morning, Mr. Ayala. How are you?
I'm good. And yourself? Good morning.
Good morning. I'm just gonna grab your attorney. Get started. So good morning. I'm Parole Officer Priscilla and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jonathan Ayala, inmate number 385595. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and our Osborne Correctional Institution. Can you please state your full name and DOC inmate number on the record?
My name is Jonathan Alexander Ayala, 385595.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Ayala.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Ayala, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights when you're ready to go forward?
Yes, ma'am.
We'll now review the charges that the state or parole officer is bringing against you and the information underlying each charge. So in charge number 1, the condition of reporting, the charging officer reported that on 9/21/22, the offender submitted proof of a positive COVID test. The offender was instructed to report to Hartford District Office at 9 a.m. on 10/5/22, which allowed for the offender to quarantine for 2 weeks. On 10/5/22, the offender did not report. The offender was instructed to report to Hartford District Office on 10/6/22 at 9 a.m. and the offender failed to report. Charge number 2, the condition of residence. The charging officer reported that on 10/12/22, the offender's parole approved sponsor stated that the offender is not residing at residence any longer. The offender does not have permission to reside anywhere else. Charge number 3, the condition of obedience to the law. The charging officer reported that between 10/17/22 and 10/20/22, the offender was in Newport, Vermont, at which time the offender was threatening the victim to drive around so that the offender could deliver drugs. The victim stated that the offender was armed with a firearm. On 10/20/22, the offender was in a vehicle which was pulled over by the police. The police found a firearm in the car as well as a scale, $3,327 in cash, and crack cocaine. The police then went to the residence where the offender was staying and found a loaded shotgun, which appeared to be shorted shotgun shells and pistol ammo. The police also found evidence of drug packaging material, including baking soda, gloves, face masks, small baggies, and a scale. Subsequently, the offender was arrested for aggravated assault, unlawful trespassing, criminal threatening, possession of a weapon while committing a crime, and possession of cocaine in violation of Title 13 and 18, Section 1024B, 3705A2D, 17024005, and 4321A3. On 3/20/26, he pled guilty or found guilty in Vermont to ag with a weapon, UT unoccupied, fentanyl sale, cocaine possession, and fentanyl sale. On charge number 4, the condition of drugs, the charging officer reported that on 10/20/22, you were in possession of crack cocaine and fentanyl. On charge number 5, the condition of weapons, the charging officer reported that on 10/20/22, you were the operator of a vehicle that contained a firearm. And charge number 6, the condition of travel, the charging officer reported that on 10/20/22, the offender was arrested in Newport, Vermont. The offender did not have permission to leave the state of Connecticut. The state has filed the following exhibits that have been identified for today's hearing as follows. Exhibit A, the remand to custody. Exhibit B, the parole violation report. Exhibit C, the notice of parole violation. Exhibit D, the conditions of parole. Exhibit E, the signed Vermont Superior Court affidavit. Exhibit F, the state of Vermont case summary number 22-CR-10349. Exhibit G, the state of Vermont case summary number 22-CR-09823. Exhibit H, the Vermont sentencing information, and Exhibit I, the waiver of extradition. In addition, the state did file an addendum to the parole violation report on March 31st, 2026 that states that on 3/20/26, the Board of Parole issued a warrant. Based on that report, Ayala received a felony conviction in Vermont while on special parole supervision. On 3/27/26, Ayala was extradited back to Connecticut. That's really it. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Perfect. And I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
I do not.
You do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So counsel.
Thank you. Briefly on the first charge, I guess, no, I didn't see any evidentiary documentation regarding the notice of report on 10/5 or 10/6. With regard to the charges, he was convicted of several offenses in Vermont. He was essentially given a time-served sentence after being incarcerated for approximately 3.5 years. He does dispute a lot of these allegations. However, given the time he had spent in jail already and the offer that was being made, he did elect to resolve it rather than risking going to trial at that point in time. I would like to know, however, one of the charges that he pleaded guilty to, the assault with a deadly weapon, I did review the arraignment report, and There's no allegation of any physical assault of any kind with a deadly weapon or without a deadly weapon. After speaking to Mr. Ayala and taking a look at that statute in Vermont, it appears the statute also encompasses threats to commit an assault. So I would just note, although the conviction says aggravated assault with a deadly weapon, I believe the subsection is under threatening. So it's really akin to more of a threatening charge here in Connecticut. So if there is a finding you would like to hear further with regard to sanction, thank you.
Thank you. My findings, on charge number 1, Mr. Ayala, I am finding that you violated the condition of reporting based on the evidence presented in State's Exhibits B and D. On charge number 2, I'm also finding that you violated the condition of residence based on the evidence presented in State's Exhibits B and D. On charge number 3, I'm finding you violated the condition of obedience to the law based on your convictions in Vermont for the assault aggravated with deadly weapon, unlawful trespassing, and the 2 counts of felony sale and dispense and cocaine sale and delivery. When you did receive the jail sentence, I'm assuming it's 3 years. It was a 3 year and
3 years and 5 months, I believe.
yeah, right. So
Down.
I think you said time served. So just note it one more time. It's time served. Sentence. In addition, the evidence in support of that charge is State's Exhibits B, D, E, and H. And on charge number 4, I'm finding you violated the condition of drugs based on the evidence presented in State's Exhibits B, D, and E. Charge number 5, I'm finding you violated the condition of weapons based on State's Exhibits B, D, and E. Charge number 6, I'm finding you violated the condition of travel based on the evidence presented in State's Exhibits B, D, E, and I. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, counsel.
Thank you. Mr. Ayala, he's 34 years old. He was born and raised by his family here in Connecticut. He does have a very supportive family who still reside in the Hartford area, and they are a strong source of support for Mr. Ayala, and he is looking forward to the time when he can reunite with his family. He did graduate from high school in Hartford. When he is released, he's going to be seeking placement in a halfway house in the Hartford area. Mr. Ayala, he does think a halfway house would be more beneficial to him as he's released from incarceration. It would provide him with some sort of more structure and a transition back into the community as opposed to a sponsor. After he does get acclimated and gets employment and works with the halfway house, at some point he will probably be seeking to transfer to a sponsorship with his family. But at first, as a transition, he is seeking some more oversight with regard to the transition. He thinks the halfway house would be beneficial to him. He has been working on advancing his education since he graduated from high school. He started taking college classes, studying business administration while he was incarcerated. And he does want to complete this degree program and ultimately graduate from college when he is released. When he was incarcerated in Vermont, he also participated in a physical training program. That's a career path he's always had an interest in, and he's going to be looking to further look into that when he's released as well. He's also expressed an interest in pursuing trade school and studying HVAC, so he does have a lot of plans going forward to continue with his education and potentially advance his career opportunities. He has a lot of different options he's looking into at this time. Prior to the arrest back in 2022, he was employed at a Trader Joe's warehouse, and he was working there for about 5 months. He has experience working in various warehouse positions in the past. He's also worked at the Boys and Girls Club. He does have an employment plan for when he's released. He's planning on working at a Campbell's warehouse in Bloomfield, Connecticut. He indicated his sister works there. She's a manager, and she's been in touch with people there, and they would have a position available for him when he is released from incarceration. Mr. Ayala, he is willing to work with parole, engage in any type of treatment that is deemed appropriate. I did review the DIS, and it did indicate that there were some mental health diagnoses some time ago. If any additional mental health counseling or evaluations are recommended, he's certainly willing to cooperate with that going forward, in addition to any type of substance abuse counseling that is deemed appropriate by parole. This is his first violation of special parole here. I know the PBR mentions 2 prior violations. However, That was a prior period of supervision. It wasn't this period of special parole. And I also note that second violation of discretionary parole, that warrant was withdrawn and his parole was reinstated in that case. I do think it's important to take into consideration the fact that Mr. Ayala has been continuously incarcerated since he was arrested in Vermont in October of 2022, which is approximately 3.5 years now. I know there was an initial remand issued back in 2022 based upon the arrest in Vermont, and it appears from the evidence that a notice of parole violation was prepared back in 2022. However, nothing was acted upon based upon his incarceration out of state and the logistical difficulty of going forward with the parole process at that time. While a second remand was issued after that sentence was completed, I do think the board should take into consideration that the 3.5 years he's already been incarcerated when issuing a sanction here in this case. These violations do go back to 2022. There was a significant sentence and penalty imposed in Vermont, and that sentence is now completed. Given all that, I would ask you to consider releasing Mr. Ayala at the next available date, as he's been incarcerated beyond the expiration of that sentence at this point and has spent 3.5 years in jail. He is looking to move forward with his life. He wants to reconnect with his family, continue his education, get back to work. As I indicated, he will work with parole, engage in any type of treatment they want for him to help with his rehabilitation. Mr. Ayala, is there anything you'd like to add?
I just would like to add that I feel it is vital for us to, well, for myself, to focus on the transition period, because being released from custody, I need to be supervised in a way where I'm still supported and encouraged to do the right thing. So as my counsel mentioned, I decided to go to transition of halfway house because I know that I'm still under supervision and there's still requirements of me. So I figure if I'm in a halfway house and I'm mandated to stay in a halfway house for so maybe a 6-month span and maintain and employment, drug screening, etc., it'll help with me staying focused. Because I found that when I'm released into society with no oversight, I start to unravel and I go back to what I'm comfortable with, the destruction that put me in the facilities, the institution through all of my life. So I feel if I have some type of structure that's implemented, like a halfway house, like stipulations that I have to do programming, etc., it will help with me being able to be successful with transitioning back into society.
Thank you, Mr.
Thank you, Mr. Ayala.
Thank you.
So I know you said it, I just want to clarify, the sentence is complete, correct? In Vermont, there's no supervision or anything?
From the information I have from the evidence, it appeared that it was complete. Yeah, it was just a flat jail time.
Flat jail, okay. So, and you were incarcerated for that entire 3.5 years up there, correct? Mr. Ayala, you didn't get out on any early release supervisions?
No,
because you're still
completed the full sentence. No, it's completed the full sentence. I was not released at all. As I expressed to my attorney, keeping me incarcerated isn't going to really accomplish anything. I've done every program in the state of Connecticut that the state of Connecticut has to offer. And then still, when I was released, without the structure, it didn't really help much because I started to unravel because I became overwhelmed and I didn't have that structure that I'm accustomed to. So keeping me incarcerated isn't going to really achieve anything when we speaking on transitioning to society and becoming a productive member of society. Keeping me incarcerated, I would continue to go about my day without getting in trouble because I have that structure, but I need to figure out a way to bring that structure into my life, into society, until I'm strong enough to be on my own and be a productive member of society.
Great. Thank you. I have listened to the testimony provided today, and I appreciate the comments and statements. So with that, Mr. Ariella, I am going to recommend that your parole be revoked and that you do serve an approximate 3.5-year period of confinement. That's with the referral date of April 23rd, 2026. That's the earliest date. That's the board review date for your case. I'm also going to recommend the following conditions: a no contact with co-defendant Elijah Stanford, Alexis Wary, Trayvon Clay, and Tisha Newth. A general no contact with JL and SR. Mental health evaluation and treatment as deemed necessary. No operation of a motor vehicle without parole officer's permission, and halfway house placement. So that does take into consideration the time spent in Vermont as well. I just put that on the record. So what happens next, Mr. Ayala, is that my recommendation is going to go to the board next week on April 23rd. On that date, the board can do two things. They can adopt my recommendation. You'll be released to supervision that day. Or they can bring you back for a second hearing. And at that hearing, they're going to address any of their questions or concerns with you before anything longer would possibly be imposed by them. So it's just to give them a chance to talk to you if they choose to do so. Okay.
Okay, I'm sorry. Would I receive your recommendation in writing, because I couldn't hear the beginning part? So I didn't really, but I didn't want you to repeat the whole thing, so.
That's okay. I'm recommending next week, April 23rd. So what happens is that I present your case to the board on the same day. So you really won't get anything in the mail or notified of it. If you walk out the door that day, then the board agreed. If you don't walk out the door that day, then you're probably gonna have to come back. Your counsel will reach out to you to discuss it further, because we'll bring you back in for another hearing if they don't agree with that recommendation of next Thursday, okay?
And I just want to confirm that date that we're going by is that first remand back in 2022, correct?
Yes.
Okay, because I don't want, like, if you impose a 3.5-year sentence, I don't want them to only credit it back till last month when he was brought back here.
No, it's credited with the time that you've spent in Vermont. So, I mean, you just got out of that sentence, right? Like, I think 2 weeks ago, 3 weeks ago. Yeah, so it's including that time frame too, okay?
All right, thank you.
Yeah, that's all for today. Any questions, Mr. Ayala?
No, ma'am. Thank you.
You're all set. This includes a revocation hearing for Jonathan Ayala and number 385-595. Thank you. Good luck to you, Mr. Ayala. Thank you, counsel.
Appreciate you. Have a good day.
Too. Thank you.
Yeah, I'll call again. I just called the block again and told them, and block officer said he's gonna make an announcement and let them know. He's not down here yet. Do you want to start with the other guy or no?
It's okay. I'm just muted. It's been the morning. Yes, sorry. Yes, please. That'd be perfect. Thank you.
Okay.
Thanks.
Once he gets down here, if he's here after you're done, I'll put him right in.
Perfect. Sounds good.
Thank you.
Thanks.
Okay, go ahead.
So. All right, Mr. Cruz, we're going to get started, okay?
Okay, no problem.
Okay, so good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Mario Cruz, MA number 302993. Today is Wednesday, April 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC and MA number for the record?
My name is Mario Cruz, 302993.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. So this is a revocation hearing, Mr. Cruz, and it is to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Cruz, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury.
I do, ma'am.
Thank you. So we're going to go over the procedure for today. So first, we're going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights and we're going to review them now. So you do have the right to be represented by an attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you, or you may hire your own private attorney. So Mr. Cruz, were you aware that you can have an attorney represent you at today's hearing?
Yes, I went through this in New Haven County. Yeah.
So you're okay with moving forward without legal
Yeah,
representation?
Yes, ma'am.
All right, you also have the right to receive the written notice that charges a violation and to review that notice. Did you receive that written notice?
Yep, I received a little file, like I guess a little vanilla envelope.
Yeah, with all of the evidence and everything, so you were
Evidence,
able to
yeah.
review all of the evidence, perfect.
Yes,
You
yes.
also have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. So do you understand all these rights, Mr. Cruz, and are you ready to move forward?
Yes, ma'am.
So we're going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number 1, the condition of program participation, the charging officer reported that on 2/13/26, you were unsuccessfully discharged from the App Foundation. And charge number 2, the condition of drugs, the charging officer reported that on or about 11/27/25, you used fentanyl, evidenced by a toxicology report. And on or about 1/1/26, you used fentanyl, evidenced by a toxicology report. All the evidence presented by the state was already identified at the preliminary hearing, so that does all remain the same. I have not received any evidence or exhibits from you at this time, Mr. Cruz. Do you need any time to submit any documents for your own behalf?
No, ma'am. No.
So at this time, it is your opportunity to call any witnesses, present evidence, and speak to the charges against you. However, I do want you to know that you have the right to remain silent if you choose to do so. So would you like to make any statements or comments or testify towards the charges against you?
No, ma'am. Just I leave it all to the Lord.
Thank you. So I am going to announce my findings, Mr. Cruz. On charge number 1, the condition of program participation, I am going to make a finding that you violated that condition based on the evidence presented at States Exhibits A, C, and M. I'm also finding that you violated the condition of drugs based on the evidence presented in States Exhibits A, C, E, F, G, H, I, and J. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So any information you want to give about your plans for sobriety, if you have any release plans, employment plans, housing plans, anything at this point?
Honestly, I want to give it a go again. I want to try App Foundation again. I want to go back into App Foundation. I don't want to go straight home. I want to still work on myself because I felt like it was really helping me out, the program. I really want to work on my sobriety, this addiction that I've been having for so long.
What other programs are you aware of to utilize for your sobriety?
IOP, I could do IOP, like Wellmore. I'll get into that again. I'll definitely get into that. I just felt like this time around, I gave up too easy. I didn't, because I wasn't able to find employment at the moment, because when I was in Osborne, I did schooling for carpentry and all that. I got my OSHA 10 and everything. And I thought it was going to be easy for me to find employment. And once I wasn't able to find employment for a few months, I just gave in. I started giving in, like I just let myself down. So this time I'm not trying to go out there on just running fast. I want to just take it one day at a time.
Do you have any plans for employment? Is there any jobs available?
Honestly, I always did barbering. That's the main thing I always did, but I always did it without having my license. Because I got the skill, but I just ain't got the license for it. So, but I always was able to work under the table with jobs. So if that, I'll probably go in for schooling with that, just to be an apprentice for schooling for a barber. Cause that's my love right there. I really love to cut hair, do styling and stuff like that.
Get licensed, yeah, absolutely, it's a good plan. I'm not sure if you'd be able to discharge straight to Apt. What are your plans for housing? Would you need a halfway house placement or do you have a sponsor? Halfway
Yeah,
house?
halfway house, yeah, yeah.
And what's the location? Bridgeport,
Either-
Hartford, Waterbury?
Waterbury, Bridgeport,
Which is your first choice?
I say Waterbury.
Waterbury? Have you looked into schools? Are there some available in Waterbury?
Not really. I looked into one, but I don't really know the name of it. It was up on Thomason Avenue, up there. So I'm checking that one. I want to see what's going on with that one. But there's different options and stuff like that. But one thing about Waterbury is that if you won't have transportation, it's kind of far, these schools. So
Yeah.
I need to find transportation to get there,
Okay.
get my license and everything.
So you still want to keep Waterbury as your first choice?
Yes, yeah. At the moment, yeah.
Okay.
Because I got family that can help me out there and stuff like that. So.
Thank you for talking to me. I am gonna announce my recommendation, okay?
Yes, ma'am.
Alright. So again, thanks for talking to me. I've listened to what you've said. Taking accountability is huge and it sounds like you are at that point. I have reviewed all the documents submitted by PCS, the evidence that we've received. So with that, Mr. Cruz, I'm gonna recommend that your poll be revoked and that you serve an approximate 4-month period of confinement as a sanction. That's with a repoll date of June 15th, 2026. I'm gonna recommend the following conditions: behavioral management program for domestic violence and anger management, no contact with co-defendants, Luis Cruz Almastica, Ana Kyrie Espinal Adams. I am gonna kill, yeah, I'm gonna try. Ignacio Henriquez Mendez, Juan Carlos Ferrero, and Jamie Molina. Also mental health evaluation and treatment as deemed necessary, and halfway house placement. So what happens next, Mr. Cruz, is that my recommendation is gonna go to the board next Thursday on April 23rd. On that date, the board can do 3 things. They can lower that recommendation if they choose to do so. So any date between next Thursday and June 15th. They can adopt the recommendation if they choose to do so. And if for any reason they would want to see a longer period of confinement, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed, okay? So that does conclude today's hearing. Do you have any questions?
No problem, ma'am. Thank you very much for not going so harsh. I appreciate you. Thank you.
You're welcome. Well, I feel like you have some plans in place. Just try to get that support you need, okay?
Yes, I definitely do. I definitely want to get this in order. And once I can take care of this, I know I'll be good. I know I can be good. Yeah.
All right. Sounds good. Good luck to you, Mr. Cruz. This concludes the revocation hearing for Mario Cruz, inmate number 302993. All right. Good luck to you, Mr. Cruz.
So June, I come, is like, would you recommend it? That's when I'll be able to go to the halfway house or?
Yeah, June 15th is my recommendation. So what, you'll get something in the mail about a week or so after next Thursday. So next Thursday, the board will vote on it. If it's changed lower, the information you receive will say that. If not, it'll say they accepted it. And then if they do want to see you for something longer, you'll know before you get anything in the mail because we'll bring you back the week after, okay?
Is it possible, could I like, if, because at Foundation also is like DOC. I mean, they take DOC inmates, like a halfway house or whatever, you know what I mean? It's pretty much like a, like DOC, halfway house, substance abuse placement.
Yeah.
I mean, I instead of going straight to a halfway house, I wouldn't mind going there for a
So
little bit.
I can just note that in the information to provide to your officer that you report to. We can't, my understanding is that there's no direct transition.
Okay.
But once you get out on that date, you can just have the conversation and maybe they can find you a bed within a week or so just to get you back into treatment. So make sure you just advocate for yourself, okay?
Thank you so much.
All right, good luck to you, Mr. Cruz.
You too. Have a nice day.
You too. This concludes the revocation hearing for Mario Cruz, inmate number 302993. Hi, Mr. Bonet. I'm just gonna grab your attorney, okay?
Hello, yes. Sorry for the absence. What's some miscommunication going on? I apologize.
Okay, commissary is important.
No, I wasn't, I was already there. So I didn't get called until right after, I got into the block.
Don't worry about it, you're fine. Come on in.
Okay.
No worries.
Yeah, I was like, I just talked to this, police officer. I was like, oh, you told him I was at commissary? I didn't skip my parole hearing to go to commissary, sir. He was like, no, I told them you were at commissary. So I came back in the dorm and you were like, Bonet to the bubble. They just had called me. I ran over here. I was sweating. I had to get some napkins.
It's okay. No, like I said, don't worry about it. We are gonna get started though, okay?
Okay.
All right, so good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Isaiah Bonet, number 3785229. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC IMEI number for the record?
Yes, my name is Isaiah Bonet, 378-529.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews, the Public Defender's Office, for Mr. Bonet.
Thank you.
Hello,
So
Mr.
this is a revocation hearing to determine whether you violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to the panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. So testimony at today's hearing will be taken under oath. So Mr. Bonet, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you have an opportunity to present any relevant testimony subject to cross-examination. That's not right. Any relevant testimony and any relevant documents. Sorry about that. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you have important rights. We're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We're going to review the charges that the state, your parole officers bring against you, and the information underlying each charge. So charge number 1, the condition of obedience to the law. The charging officer reported that on the morning of 12/5/25, you were at 202 Coleman Street in New London. A video was reported of you threatening a family member with a red folding knife, stating that you were going to kill them. New London police arrested you for threatening second and disorderly conduct. Charge number 2, the condition of weapons. The charging officer reported that you were taken into custody by police. When you were taken into custody by police, you were in possession of a red folding knife similar to the one you were seen holding on camera during the threatening incident. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the notice of parole violation. Exhibit B, the parole violation report. Exhibit C, the remand to custody. Exhibit D, the signed parole conditions. Exhibit E, the New London Police Report, case number 25000311059, and Exhibit F, the continuance from New London Court. In addition, the state did file an addendum to the parole violation report on March 10th, 2026, that states that Mr. Bonet appeared in New London Court on 3/9/26. The charge of disorderly conduct was nullied and he was sentenced to 6 months jail for the charge of threatening second. And that there were no pending charges at the time. So counsel, to confirm, you and your client did receive the notice of parole violation for and all the other documents identified for today?
Yes, we did.
I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole and statement. Exhibit 2, character letter from Rachel Gable. Exhibit 3, a support letter from Donnell Brown, founder and director of Asset Music Group LLC. Exhibit 4, 9 certificates. Exhibit 5, the offender work performance in program form. Counsel, do you need time to submit any other documents?
No, I did not.
There are no witnesses present today. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and to speak to any of the evidence submitted. So counsel?
Thank you. So Mr. Bonet, he did enter a plea in court. It was a plea under the Alfred Doctrine. He does dispute a lot of the allegations that were contained in the police report. I just wanted to add a little additional context to Mr. Bonet with regard to what happened. First, while the complaint was his nephew, Mr. Bonet's nephew is the same age as Mr. Bonet. So it wasn't as though this was an incident involving a young 18 or 19-year-old kid. He was somebody who was the same age as Mr. Bonet. Mr. Bonet indicated he was working as his mother's PCA, and there had been some verbal disputes over the course of the day between him and his nephew. At the time he was leaving, he indicated his nephew grabbed Mr. Bonet physically, and unfortunately the situation did escalate. He does accuse some of the allegations, but he does acknowledge that he could have handled the situation differently, and he's apologetic about what happened. Nobody was injured in this incident. It was an isolated incident. He was otherwise doing very well. So if there's a finding, it would like to be heard further with regard to sanction. Thank you.
So I'm gonna announce my findings. So in charge number 1, Mr. Bonet, I am finding that you violated the condition of obedience to the law based on your conviction of the threatening second when you received that 6 months jail sentence. In addition, the evidence in support of the charge states exhibits B, D, and F. And I'm also finding that you violated charge number 2, the condition of weapons based on the evidence presented states exhibits B, D, and E. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation on the opportunity to speak to your background and history, the purpose of this part of the revocation hearing is to help determine what I'll recommend. So counsel?
Thank you. Mr. Bonet, he's 33 years old. He was born in Connecticut. He graduated from high school in New London. He had a difficult childhood. He did move around some due to being under the care of PCF. However, his mother still resides in Connecticut, and he does have a good relationship with her. He also has a fiance who's a good source of support as well. And he is looking to be sponsored by his fiance, who does reside in New London. She's been approved as his sponsor in the past, and she did provide a reference letter, which was submitted as an exhibit. It was a very good letter. She's very supportive of Mr. Bonet. When he was initially released to supervision, he did complete a halfway out program successfully. He did transition to a reach bed, which he complied with, and then he eventually transitioned to his own apartment. He did continue his education after high school. He attended trade school. He has certification in graphic design. He's been working on obtaining additional certifications to assist him in his career opportunities in the future. Some of those have been attached as exhibits. There was a first aid certification, an OSHA certification, a flagging and traffic control training, as well as some additional employment skill training programs, which he had completed successfully. Prior to the remand, Mr. Bonet was working several jobs. He was employed at a Foxwood Casino as a cashier and sales associate. And I previously indicated he was working as a PSA, assisting his mother with her medical care. She does have a lot of medical issues, and she does rely on Mr. Bonet to assist her with her care. Mr. Bonet, he was also working with a music production company as a performing artist. He's very enthusiastic about music. And the director of Asset Music is very supportive as well. Also provided a character reference letter, which was also included as an exhibit. When he is released, he's hoping to continue working on his music, developing a career as an artist. However, he does understand he's going to need to further support himself financially until that becomes a full-time position. And there's a lot of other employment opportunities he's had in the past. He's always been able to obtain work. He's always been successful at his jobs that he's held. He's a hard worker. Right now in corrections, he has a position as a janitor. I did provide the documentation of that. He has excellent performance reviews on that position. He's always been an excellent worker, and he's confident he'll be able to do that in the future when he is released. Mr. Bonet, he has been under supervision for almost 2 years prior to the remand in December of 2025. The PVR indicated he was doing very well on parole. His parole officer indicated that he was employed, complying with treatment, had no misconducts during those 2 years of supervision. I do feel that does demonstrate a willingness and ability to cooperate with parole. He certainly plans on continuing to do this in the future. He does have some plans going forward to try to ensure something like this does not repeat itself. I understand that the complainant in his criminal matter wanted Mr. Bonet to engage in some mental health counseling. And that's something he does intend to do as he feels that will be helpful to him going forward. He had a tough upbringing as a ward of the state. It did lead to some mental health challenges. And I do think addressing these issues head on can assist them going forward and complying with parole and trying to prevent something like this from escalating. He has been involved in counseling in the past at Connecticut Behavioral Health. He has diagnoses and he's been cooperative with that treatment. He has a mental health counselor in corrections, and he does plan on re-engaged counseling when he gets out. His fiance has also been in contact with SCAD to see if he can enroll in an anger management program, and he's certainly willing to do that as well if parole feels that would be appropriate to address some issues. He's been working hard on parole for a long time prior to this remand. He does know that he needs to continue to address some underlying issues. I know his PO is recommending that Mr. Bonet be released to continue his supervision after the case is resolved. I would also ask the board to adopt that recommendation. He's been incarcerated now for a little over 4 months. I do think he's demonstrated he can work and benefit from parole. And I would ask that he be given the opportunity to get back to his family and continue working with parole as he was doing prior to this remand. Mr. Bonet, is there anything else you'd like to add?
Yeah, I wrote a letter for the parole board, if you wouldn't mind, if I could read it. But I do have opportunities from my CEO, my music group. I have work opportunities that is available for me upon release through him. I also have a couple options through as cook through the Norwich Public School District. I know people that work there as well.
I'm sorry, what school district?
The Norwich Public School District. So I have friends in a lot of places that are willing to help me, during this time if I were to be released.
Thank you. You said you had something you wanted to read, Mr. Bonet?
Yes, I have a letter I wrote for the board.
Go ahead.
To the honorable members of the parole board, I wrote this to express my sincere remorse for my actions that led to this hearing. I take full responsibility for my mistakes, knowing I'm far from perfect, and acknowledge I violated the conditions of my parole. And for that, I humbly apologize. I deeply regret the poor decisions I made because of the negative effect and impact it's had on my life and my loved ones. I've been the backbone for my fiance and my stepson, and I'm needed now more than ever. My absence has caused pain and struggle financially and emotionally for my fiance, my stepson, my support system that I have, and my life. During this time I've been incarcerated, I've thought and reflected on my behavior that put me here, and I realized it was wrong. I should have handled it in an entirely different manner. I have taken steps since my remand to address these issues that contributed to my violation. I have been attending anger management therapy with great poise and also mental health groups, where I've learned coping mechanisms to avoid repeating past mistakes, and I will continue therapy when I'm home, if that's granted. My goal is to reintegrate back into society, continuing my journey in life, striving to become a better version of myself than I already am. I'm asking today for your consideration and understanding as I seek another opportunity to continue my rehabilitation outside of confinement, where I have a greater chance of success because of resources and opportunities I can obtain. I have come so far in the past 2 years, and I would like to show parole and prove to myself I can continue to be a productive, law-abiding member of society for the remainder of my time on parole. I promise to adhere to all conditions going forward by leading a responsible, constructive, positive life while working, attending treatment, and gaining knowledge to receive my CDL. I cannot and will not waste another chance nor time to demonstrate I've learned from this and will excel in all aspects of life. I appreciate and thank you for taking this moment in time to listen to my plea and considering my sincere appeal. With much thought and respect, Isaiah Bonet.
Thank you, Mr. Bowman.
Thank you.
Take a moment and I'm gonna announce my recommendation. So I have listened to the testimony today, reviewed all the documents submitted. I do want to note on the record, this is Mr. Bonet's second violation on special parole. Both have been criminal violations. However, prior to this violation, you were out and on supervision for approximately a year and 10 months, I have. And per the parole violation report submitted by your supervising officer, it does state that you're working 2 jobs, secured your own apartment, no misconducts, were compliant up until this arrest. So I also am acknowledging you're taking accountability for what took place as well. So with that, Mr. Bonet, I am going to recommend that your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. That's with the recall date of June 5th, 2026. I'm going to recommend the following conditions: behavioral management program for domestic violence, no contact with ER, a general no contact with MC without parole officer's permission, a general no contact with ML. Is that the name of the current victim?
No.
ML, is that,
Oh,
that's
yeah,
not
yeah,
your
yeah,
nephew's
yeah,
name?
yeah, yes.
ML?
Yes.
Okay, and is your nephew, so I'll do without parole officer's permission. Do you guys will be around each other? Is that true?
No,
Like,
I don't think furthermore, I'll be around my nephew.
Okay, so I'm gonna do no contact with ML without parole officer's permission. So just make sure you have a conversation if anything, if you do need to be or whatever takes place, okay?
Okay.
That PO's permission, mental health evaluation and treatment as deemed necessary, and I'll note your sponsor's information in New London, okay? So what happens next, Mr. Bonet, is that my recommendation is going to go to the board next week on April 23rd. On that day, the board can do 3 things. They can lower my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. Okay, so that does conclude today's hearing. Do you have any questions?
No, I do not, ma'am.
So this does include the revocation hearing for Isaiah Bonet, I number 378529. Good luck to you, Mr. Bonet.
Thank you so much. Have a great day. You too, Mr.
Council.
Hello, is there any way you can tell me like an order?
If you have Mr. Pasquale, that'd be perfect. I think that's how do you say his name?
Yeah.
No, that's his first name. So Mr. Raffone, and then Nelson, Dorlet, and then Stearns, please.
Okay.
Thanks.
Okay, I want to see this guy first for phone. 64. Farmington, East Side. Okay, they actually want to see certain last. They want to see Stearns last. Parole wants to see Stearns last. Yes, so. No, he's only want the last. Correct. No, so I'll call the ones to the other, hearing them. All right. He was ready to do that? All right, good, okay.
Hello,
Good morning, Mr. Phone. How are you?
good, how you doing?
Good. So it is 10:45. We're just waiting to see if your officer logs in. They have about 5 minutes to get logged in before we can get started without them present. Okay, so just hang tight for a few minutes.
Okay,
You have a chair in there?
Yeah, is there no chair?
no chair. Oh,
Do you
I can
wanna-
grab one.
Yeah, I
can
mean,
grab
Why don't you grab a chair?
yeah, you might be more
Okay.
comfortable. Yeah.
Thank you. Yeah. There's a chair there. Chair? Much better.
Yeah, thanks. So yeah, we'll get started shortly, okay?
Okay.
Name's like on the foot.
All right, so we are gonna get started, Mr. Flynn. I just want to note on the record that we have given Pearl Community Services the allotted time to log in as per procedure at this time, and we have tried to send an email to ask the officer to log in, and there was no response, as well as tried to send a call to her device, and again with no response. So we are going to move forward. So good morning. I am Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Pascual Rafon, inmate number 308999. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Can you please say your full name and DOC inmate number for the record?
Pascual phone, inmate number 308999.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office and Mr. Rafone.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the charges of your conditions of parole, I will reinstate parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to the panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Rafone, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, full truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
We will now review the charges that the state, your parole officer is bringing against you and the information underlying each charge. So on charge number 1, the condition of obedience to the law. The charging officer reported that on 12/11/25, New Haven PD admin was obtained surveillance footage from Scott Schaefer's Lowe's Asset Prevention. The footage obtained on 12/11/25 at approximately 16:13 hours shows you, a Sprawler phone, placing a Rothinger 75-foot machine auger valued at $799 in your car. The officer contacted you via cell phone and informed you that Lowe's Asset Protection provided a still image and video footage of you taking the item without paying for it. You agreed to meet at 1 Union Avenue where you were charged with Connecticut General Statute 53A-125A, larceny in the 5th degree at 900 hours. You are scheduled to appear in New Haven GA 23 on 2/26/26. On 2/11/26, East Haven Police Officer Francisco Ortiz responded to the East Haven Home Depot 75 West Frontage Road. The officer spoke with loss prevention agent Mr. Kevin Henniger, who stated that he stopped you from making a fraudulent return at the customer service desk. You were observed walking to the lumber and housing aisle and selected a large 36x84 entry door and some other items. You then walked up to the customer service desk and attempted to return the same door with the old sales receipt. Mr. Henniger approached you and informed you that he was aware of the fraudulent return and you admitted it. You were arrested and charged with larceny 6th degree 53A-125B. You were scheduled to appear in New Haven GA 23 court on 2/26/26. Charge number 2, the condition of notification of arrest. The charging officer reported that you were arrested by New Haven PD on 12/11/26 and failed to notify your parole officer. On charge number 3, the condition of general no contact with, the charging officer reported that on 2/11/2025 you entered the Home Depot 75 West Frontage Road, East Haven, Connecticut. Based on your actions, you violated your BOPP general no contact condition. On 2/11/2026, East Haven police officers responded to the East Haven Home Depot 75 West Frontage Road, and officers spoke with loss prevention agent Kevin Henniger, who stated he stopped you from making a fraudulent return at the customer service desk. You were observed walking to the lumber and housing islands, like the large 36x84 entry door and some other items. You then walked up to customer service desk and attempted to return the same door with an sales receipt. Mr. Henniger approached you and informed you that he was aware of the fraudulent return and you admitted it. You were arrested and charged with larceny 6th degree 53A-125B. The state has filed the following documents that have been identified for today's purposes as Exhibit A, the Connecticut Conditions of Parole. Exhibit B, the Connecticut Board of Parole remains actual custody. Exhibit C, the Notice of Parole Violation for Rights. Exhibit D, the Parole Violation Report. Exhibit E, the Police Report. Exhibit F, the Judicial Pending Case Details /Minute. Exhibit G, the Decision Information Summaries. Exhibit H, the Revocation Summary. Exhibit I, the Misconduct /Voluntary Admission Forms. In addition, the state did file an addendum to the Parole Violation Report on March 4th, 2026. That states that on February 26, 2026, Mr. Raffone appeared in GA Court, New Haven Court GA 23 and was pled guilty to the charge of larceny 5th and received a 6 months jail sentence, execution suspended, conditional discharge 18 months. And that was under docket number 528S. And then under docket number, he was also heard, and that's 447S, for the charge of larceny 6th degree, at which time he did plead guilty and received a 3-month jail sentence, execution suspended after 30 days, with conditional discharge for 18 months. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Great. I did receive exhibits from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, a character letter from Gianna Vallejo. And Exhibit 3, the treatment letter from Daniel J. Varley, LCSW. Counsel, do you need time to submit any other documents?
I do not.
You don't have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and to speak to any of the evidence submitted. So counsel?
Thank you. Just to begin with, from a from a procedural perspective, taking a look at Exhibit C, it doesn't appear that the regulations were complied with regard to serving the notice of the parole violation within 3 business days. It was being made on the 11th. First date of that notice being signed appears to be the 18th, which is more than the 3 business days. With regard to the actual charges, Mr. Affone did enter pleas for these 2 charges in court. However, I will note that he does dispute these allegations still. However, his desire to schedule a revocation hearing, there was a lot of pressure on him to resolve it, and he did enter those pleas. But he does want the board to know that he does dispute a lot of the evidence that was presented in those police reports. With regard to charge 2, I just want to ask Mr. Affone a few questions. Mr. Affone, did you report your arrest from December 11th, 2025 to your parole officer?
I did. I notified P.O. Ben via voicemail, as that's the only number that was available to me. She never gave me her cell phone number. So I did leave a message on her voicemail. Unbeknownst to me, a couple weeks after that, there was a knock at my residence on the door. And apparently I had a new parole officer, which was P.O. Curry, I believe. And then I reported to her the next day after the home visit. And then when I was served the papers, I had yet another parole officer, P.O. Barnes. So I don't, at this point, I don't even know who my actual parole officer is or was, or it was very confusing. So.
Okay, but you indicated you reported to who you thought your parole officer was at the time, and then did switch
Exactly.
a couple times after that.
Exactly.
All right, thank you. If there is a finding, I would like to be heard further with regard to the sanction. Thank you.
Thank you. Take a quick recess. So Mr. Raffone, keep calling you by your first name. Mr. Raffone, I'm gonna take a quick recess, just to council understand that it's still live stream.
Yes.
I'll be right back.
Thank you. Are we allowed to speak during the recess or?
No, she should be back in a minute.
I just wanted to clarify the sentence from the court. That it was 30 days to serve, 6 months execution suspended. I don't want to think that that 6 months sentence is active. As it may reflect on any sanction, as well as my medical issues.
Yeah, we'll get into that. We'll get into that going forward.
Okay.
And you'll let you have to speak as well.
Thank you. Thank you.
Alright, so I am gonna go back on the record. I do just want to note that the reason I took a recess was because council statement about, the dates of the remand to the signing of the, paperwork, and I just wanted to confirm that Mr. Rafon's due process rights were not violated. Just so you're aware, council, there was a holiday in. So 13 business days, the holiday is recognized by the state of Connecticut. is the 18th, which is when he signed the first.
Well, isn't it 3 days from the date of remand?
It's 3 business days from the
right?
date.
So it's the 11th of the,
Okay, yeah,
1 second.
no, that's fine.
So what was the holiday?
The holiday was the, I know we had the 12th.
The 12th was a holiday?
Yep.
Oh, they're 12 days?
16.
Okay.
So we had 2 holidays. I don't know about that. I only got the 1 too. So with the 2 holidays, fortunately, or fortunately, whichever way you want to look at it. So I was just concerned that your due process rights were violated, Mr. Fong. So sorry for the delay. We're gonna.
I did have a question regarding all that due process. I pled out in 2013 to special parole. Well, we have to follow the guidelines that were implemented back in 2013, not 2020.
Yeah.
Like under old law versus new law.
Yeah, unfortunately, right, we just gotta follow what's put in front of us. So, I am gonna, counsel anything further towards the charges at this time.
Nothing else for the charge.
So I am gonna announce my findings then, on charge number 1, Mr. Rickon, I am finding that you violated the condition of obedience of the law based on your conviction on 2/26/26 of the larceny fifth, when you got the 6 months jail sentence, execution suspended, followed by the 18-month of conditional discharge. In addition to that, conviction of the larceny 6, when you received a 3-month jail sentence, execution suspended, followed by after days, followed by the 18 months of conditional discharge. In addition, the evidence in support of the charge is states exhibits C, D, E, and F. On charge number 2, I'm making a no finding a notification of arrest. Based on the charge details, it's a futuristic date. It's actually impossible that you did not report that arrest on that date that was written in the notice. And then on charge number 3, I'm also finding that you violated the condition of general no contact with the evidence based on the evidence submitted in states exhibits C, D, and E. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel.
Thank you. So Mr. Raffal, he's 61 years old. He was born and raised in Connecticut with his family. He has a lot of family support in the state, including his sister, his daughter, as well as many aunts and uncles who he has a very good and supportive relationship with. Prior to the remand, he was self-sponsored at his residence where he's been for several years. He has been in touch with his landlord. His landlord has indicated that he can return to that residence when he is released. When he was first released to parole back in 2018, he did successfully complete a halfway house program, but since then he's been self-sponsored for some time now. His very close friend, Gianna Polk, does reside with them. She did provide a letter of support, which was attached as an exhibit, and she's very supportive of Mr. Raffon, as indicated in her letter. Mr. Raffon, he's an entrepreneur. He's been operating his own roofing business successfully for the past 4 years since he was last released from incarceration. His business is doing very well. He has employees, he's licensed and insured, and he's been very successful in growing his business over time. When he's released, he's planning on going back to work in his business, and he's very optimistic he'll be able to get things up and running very quickly and get back to work very quickly. He has been cooperating with parole for many years now. He was last released in 2022, so he's been under supervision for 4 years since his last period. And he's been doing very well. The PBR mentions only 2 positive drug tests back in 2024. But other than that, there are no listed misconducts during that 4-year period. Mr. Raffon, he has been actively engaged in substance abuse treatment. He was involved in the Ford Clinic through Yale University for treatment for some time now. He did start working with them back in 2025 after that second positive drug test noted the PBR. And the letter provided indicates that he's been very successful with this treatment. He's rendered a negative urinalysis. He's continued with the program beyond the completion date on a voluntary basis. So he does have a good relationship with his counselor there. He's willing to re-engage the Ford Clinic going forward when he is released from incarceration. He's willing to engage in any type of treatment that parole feels to be appropriate, and he's always complied with the treatment recommendations made. And there's been a lot that he's done, which has been delineated in the exhibit submitted by our social worker. So Mr. Raffon, he does have some recent medical issues arise since his remand. There was a lesion found on his liver, and he does need to get that biopsied. That has been causing him a lot of anxiety. as he's been unsuccessful in trying to get this biopsy performed while he's been remanded. But he's very anxious to get this addressed when he gets released from jail. The parole officer has recommended that Mr. Raffone have his parole revoked and he served the remainder of his special parole sentence incarcerated. I do disagree with that recommendation. I think he's demonstrated an ability to be successful and work with parole over an extended period of time. 4 years of supervision with minimal noted issues is not insignificant, and I think that should be taken into consideration by the board. The PBR also mentions that he has a history of larcenies at Home Depot and Lowe's. I would just note that the last larceny conviction on his record goes back to 2013, which is 13 years old. So if any of those convictions are related to shoplifting at Lowe's or Home Depot, first of all, that's not the most egregious violation. And second of all, it's a very dated allegation. The two convictions here are both misdemeanors and the imposed sentences are conditional discharges. There's no allegation of violence in any of his prior convictions. He's worked hard to turn his life around, build a successful life for himself after incarceration. These two incidents are very unfortunate. He's apologetic for what happened here, but he's been working hard to support himself and really do well in his life after these more serious convictions he's had. Given the manner in which these cases are resolved by court and the extensive length and time he's been under supervision, I would ask for him to be released the next available date. He's looking forward to getting back to his family, to his career, and completing the rest of his supervision. Mr. Raffone, is there anything you want to add?
Just as far as the recommendation by P.O. Barnes, he doesn't know me as an individual, as a person. Like I said, that was the first time I ever met him. If he had spoken to P.O. Ben, who was my parole officer for like the past 3 years, I believe the recommendation would have been a lot better. I mean, but that's all I have to say. I'm happy with his counsel. I'm happy with the proceedings.
Thank you, Mr. Raffone. Thank you, counsel. So I am going to announce my recommendation. I have listened to the testimony today. I reviewed all the documents submitted. I do want to know on the record, as counsel stated, you were out in the community for over 4 years. I have 4 years and 1 month between your last release and remand. This is your second violation on special parole, but again, that's a lengthy period of time. It sounds like you were doing well, as counsel stated, employed, had your own housing. So the last two, you only have one misconduct also from what I see, and that was from 9/2024. So again, dated. So with that, Mr. Raffone, I am going to recommend that your parole be revoked and that you serve an approximate 3-month period of confinement as a sanction. That's with a re-parole date of May 13th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, no contact with Home Depot in East Haven, and no contact with Lowe's in New Haven. No operation of a motor vehicle without parole officer's permission, and I will put the information in for your apartment that you have independent housing. So what happens next is that my recommendation is going to go to the board next week on April 23rd. On that date, the board can do 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed, okay?
And what was that date again? To be released?
May 13th?
May 13th, okay.
May 13th, yep. So you'll get notified in the mail approximately a week after next week's hearing with the information of what they decided, okay?
Okay, I appreciate it.
So this does conclude the revocation hearing for Pasquale Raffone, inmate number 30899. Good luck to you, Mr. Raffone.
Thank you. Have a good night. Thank you.
Well, sorry.
Hi, Mr. Nelson. You're Mr. Nelson, correct?
Good morning, yes.
Morning. All right.
Yes.
Your attorney should be on his way in and then we'll get started, okay?
All right,
All right.
yes.
Mr. Nelson. Ready?
Take about an hour, go letter, just
So good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning George Nelson, inmate number 414045. Today is Wednesday, April 14, 2020. It's not, it's April 15. Sorry about that. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
George Nelson, 414045.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Nelson.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as each of the charges against you. The state not you has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Nelson, can you please raise your right hand?
Yes.
Solemnly swear, solemnly and sincerely affirm as the case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
So we are going to go over the procedure for today. So first, I'm going to read your rights. You're all set. You can put your hand down. Thank you. We're going to then review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present on today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
All right, so you do have important rights today, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights? Are you ready to go forward?
Yes.
Great. We are not going to review the charge of the state your parole officer is bringing against you and the information underlying that charge. So charge number one, the condition of obedience to the law. The charging officer reported that on December 20th, 2025, you were involved in a domestic disturbance at your Albion Street residence involving the victim ND. During the incident, you struck the victim in the face, leaving visible marks, and then proceeded to strangle her, causing her to fall backwards between the couch and the refrigerator. The victim reported that in order to get away from you, she had to lock herself in her son's bedroom. Officers responded to the scene, observed small marks on the left side of the victim's face and underneath her eye. Based on your conduct and behavior, you were arrested by the Waterbury Police Department, which is in violation of your parole conditions of release. You were subsequently charged with Connecticut General Statute 53A-64BB, strangulation in the second degree, and 53A-182, disorderly conduct. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the parole violation report, Exhibit B, the notice of parole violation / rights, Exhibit C, the remand to custody, Exhibit D, the conditions of parole, Exhibit E, the Waterbury Police Report number 2500121-467, Exhibit F, the decision information summary, and Exhibit G, the judicial pending case detail docket number 647-S. In addition, the state filed an addendum to the parole violation report on March 23rd, 2026 that states that on December 20th, 2025, Mr. Nelson was involved in a domestic disturbance in his approved residence. On February 26th, 2026, Mr. Nelson appeared in Waterbury GA4 under the docket ending in 647S, and his case was sentenced and disposed. Nelson's original charges were substituted down to 53A-181A, creating a public disturbance. Nelson entered a guilty plea and was sentenced to a $50 fine. Counsel, to confirm, me and your client did receive the notice of parole violation, the parole violation report, and all the other documents in the court today. And I did receive one exhibit from the defense, Exhibit 1, how listed full accomplishments and future plans for parole reinstatement. Counsel, do you have to submit any other documents?
No.
Not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to any of the evidence.
Yes, I just clarify your addendum you have that was submitted PCS. You have the case being resolved on February 26th of 2026. Is that correct?
Yes.
All right, could you tell me what day your addendum submitted by PCS is?
I think by procedure, it's 14 business days.
Correct. Was it received within that time frame?
Counsel.
It was received on March 23rd of 2026. I just want to put on the record, our secretaries, paralegal, social worker, we all track cases that are, when our clients have criminal charges in court. And on 2/26/26, my secretary did send a request for an addendum, which was not responded to. And then it made it to my desk and I sent an email on March 23rd of 2026 to the supervisor. No response. And 3 hours after I sent that email, the addendum appeared here at the Board of Pardons and Parole. So that addendum was not sent within the 14-day requirement. I just want to make sure that's clear for the record. Regarding the actual charge, the obedience to the law, I understand is charged for the PVR, the obedience to the law. Those charges on paper are relatively serious charges. But as we know, the PVR, when there's a criminal charge, you take a look at the police report and more or less summarize what's in the police report. Now, as an attorney in criminal court, a police report can't just be submitted into evidence at a trial because that's all hearsay. So it's what the police officers gather at the scene via statements, what they, view, and they write a police report. But a police report cannot be submitted into evidence at a criminal trial. It's all hearsay. Testimony needs to come through witnesses and things of that nature, and prosecutors have a certain burden of proof to meet, which is different than here. I'll give it that. But if by charges that he was charged with in criminal court, to go from those charges to creating a public disturbance, which is an infraction with a $50 fine, is night and day, in my opinion. So clearly, what was in that police report, for a prosecutor to change those charges, there had to be some substantial differences in what was said in the police report, testimony, through investigation. I just want to make that abundantly clear as to what happened in this case, to go from those charges to creating a public disturbance, which turned it into an infraction with a $50 fine for an individual that's been out since March 15th of 2020. That's all I have for the first part of the hearing. And I just want to add, I understand the burden as far as criminal court and the Board of Pardons and Parole. I get the standard line at these hearings that the conduct meets the elements of what the hearing examiner has to look at. But in this particular case, it's troubling because that conduct in criminal court went in the total opposite direction. And my argument I make all the time, if our client has police contact, if there's an arrest, it automatically meets the elements of what they're charged with via a police report, which is very unfair to our clients, in my opinion, with the understanding there's two separate standards.
Thank you. Let's take a moment and I will announce my findings. So I have listened to the argument presented by counsel today, and I've also reviewed all the evidence submitted. And I do understand what counsel is stating. However, what court chooses to do is at their own discretion. And as you clearly stated, our behavior, things in our standards to me is the preponderance of evidence. So it is a different standard, Mr. Nelson, just so you're aware of that. So although that the court did convict you of only an infraction, it doesn't negate that the behavior occurred. So with that, I am making a finding on charge number 1, the condition of obedience to the law based on the evidence presented in states exhibits A, D, and E. So just conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine. So counsel?
Yes, on behalf of my client, Mr. Nelson, as I indicated, he was paroled on March 15th of 2021 is what I have. He's not remanded until 12/22/25. He was out for quite a bit of time, almost approximately 4 years. He's 43 years old. He does have one child. He was born in New York. He was raised and then he moved to Waterbury about 15 years ago. On his release, looks like in March 2021, he did successfully complete the Project More Halfway House program. Then he was at the New Opportunities Halfway House program. It was a Connecticut Renaissance. And then he also self-sponsored in April of 2025. He did report to us. He did graduate from high school in New York. As far as his employment, while he was out in the community for those 4 years, full-time server and cashier at the Turkey Hut in Waterbury for approximately 2.5 years, which is a family business. Also started a landscaping business approximately 2.5 years ago out of New Britain. He has successfully completed some anger management at Midwestern Connecticut Council in from April of 2025 to May of 2025, and did report to us he did successfully complete additional outpatient behavioral health in 2021. As far as his plan for reinstatement, he can return to independent housing. Apparently, it's been kept up to par with the rent since he's been remanded. That's where he was. He tells it's still available with the understanding. I know parole officer is going to have to check all that out. Does want to enroll in cosmetology program for barbering. And he indicated to us he can return to his position at the Turkey Hut and his landscape company, and he's amenable to any treatment recommendation. As indicated, he has completed treatment while out in the community. Mr. Nelson, anything I left out that you feel is important or anything I said is incorrect? She wants to know not about the first part of the hearing, about your background and what your plan is for when you get out. Anything you want to add, now's your opportunity.
No, you said everything. Thank you.
Okay.
Thank you, counsel.
If I may just add one additional comment, based on the length of time my client was out, based on what occurred in court, I am asking for my client to be re-paroled as soon as possible, given the length of time he was out. Singular violation of the obedience to the law, which turned into an infraction. Thank you.
Thank you. So I have reviewed all the evidence submitted. Mr. Nelson, I've also listened to the testimony today. I do want to know a few things on the record. This is your first violation on special parole. I had that he was on supervision for approximately 3 years total, just because he had been incarcerated in New York back earlier. So I have about 3 years, which is still a long period of time, especially when the evidence submitted doesn't state any graduated interventions or sanctions. And states that you were employed the entire time. So with that, I am going to recommend, Mr. Nelson, that your parole be revoked and that you serve an approximate 4-month period of confinement as a sanction. And that's with the re-parole date of April 23rd, 2026. I'm going to recommend the following conditions: a behavioral management program for domestic violence, no contact with victim SC and HK, a general no contact with ND, a mental health treatment, and then I will put the information for your self-sponsor apartment. So what happens next, Mr. Question halfway house? Now he has an apartment, but
We
if
can
it's,
put it for as a second choice.
the board agrees with me, I'm just
yes.
afraid.
I have an apartment.
I know, but there's more to it, because my recommendation, what happens, Mr. Nelson, is my recommendation is gonna be for the same date as the parole board reviews your case. So if they agree to it, you'll be released that day. And I just don't know what parole and community services. Go ahead, counsel.
Yes, Georgia, obviously I'm trying to get you out as soon as possible with the understanding the board has to adopt this recommendation. With the understanding you do have an apartment, but for some reason you're going to be hopefully released on the 23rd. If they can't verify that day, you might have to go into halfway house for like a few days or a week until they verify that your apartment is still available.
Oh, okay.
So we're only gonna do the halfway house placement stipulation as a backup plan.
Just a backup. She's not asked as a first choice. We want you to go back to your independent housing.
I've noted that you've been paying the rent's done for the month, so it's just that because of the time frame, that my recommendation is. just so that there's no holds up with anything. However, Mr. Nelson, I do want you to be aware that the board can do two things on that date next Thursday. They can adopt it, which means you would be released that day. And then if for any reason they would want to see a longer period of confinement as a sanction, they'll have you come back for another hearing to address their questions and concerns before anything longer is imposed, okay?
All right.
That does conclude today's hearing. Do you have any questions?
No, I'm good.
If I just read, she indicated, Mr. Nelson, next week on the 23rd, you'll know if they adopted the recommendation because you'll be released that day. If you're not released, that means they didn't adopt it. I'll set up a legal call with you and cover the next step with you.
All right, thank you.
All right, good luck to you, George. Just keep doing what you were doing while you were out.
This concludes the revocation hearing for George Nelson, inmate number 4144045. Good luck to you, Mr. Nelson.
All right, thank you. Have a good day.
Too.
Morning.
Good morning, Mr. Dorlat. We're gonna get started in a moment, okay?
Okay, no worries, man.
Ready?
Good morning, Mr. Dorlat.
Good morning, how you doing, sir?
Good, good, good.
All right, we're gonna get started. So good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Barla?
Foul?
Sorry, all right,
Nah,
Mr.
sorry,
Dorlat.
sorry. Yes,
We're gonna
ma'am.
just call you Mr. Dorlat, inmate number 306-054. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Institution. Please state your full name and DOC inmate number for the record.
306054, ma'am.
Thanks, and just your full name for me, please.
One more time, please.
Can you just state your full name for me, please?
Oh, it's Faul Dorlet, FAROULHDORLETTE.
Thank you. So this is a public hearing that has, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the
Sure.
record?
Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Mr. Dorlat.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Dorlet, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're gonna go over the procedure for today. So first, I'm gonna read your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
If you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
If I may answer for Mr. Dorlat, can I just put something on the record for you?
No worries, no worries.
Yeah, before you go. So we received the case. I spoke to Mr. Dorlat on April 10th. And when I spoke to him, he did not physically have the evidence in hand, but I did go over the pieces of evidence with him. And then I reached out, I believe you were on the email also. It had gone in the mail the day prior to. So I guess the question that should be asked is, did he receive his documents in the mail?
Did you receive that packet of the evidence?
I actually just received the evidence yesterday. I did notice some discrepancies that I didn't have the chance to speak with counsel about, but I'm pretty sure it probably could be addressed during this hearing.
Okay, the other option is, it's not my call, it'll be your call. We can continue this hearing. I prefer not to, but it's not my call. Because it's just for the probable cause to review the evidence. Because I have it already. I know what I want to put on the record. And if you feel I missed something, I can certainly have you add it through testimony, okay?
I have no worries with that. I'm fine with going forward.
All right, so we're gonna go forward.
Okay, all right, no problem. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do, ma'am. Yes, I do.
We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number one, the condition of reporting, the charging officer reported that on 12/22/25, you signed your conditions of parole indicating that you understood your responsibilities to report to your assigned parole officer. On 3/24/26, you were scheduled to report to the Waterbury Parole Office to meet with your assigned parole officer as directed. On 3/24/26, you failed to report to parole. On charge number two, the condition of GPS, the charging officer reported that on 12/23/25, you signed a GPS monitoring agreement indicating you had understood section number 4, making you responsible to ensure your GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electrical outlet for at least 2 hours each day. On 2/1/26, you allowed your GPS to shut down from 7:23 p.m. until 10:40 p.m. On 2/7/26, you allowed your GPS to shut down from 5:45 p.m. until 7:53 p.m. And on 2/23/26, you allowed your GPS to shut down 3 times, 5:55 a.m., 3:52 p.m., and finally 4:49 p.m. Charge number 3, the condition of program participation, the charging officer reported that on 3/17/26, Wheeler Clinic's domestic violence progress report indicated that you were discharged from the program before completing your 26th session requirement. You were removed from the program after 4 unexcused absences, and you were absent on 1/8/26, 1/22/26, 2/26/26, and 3/5/26. On 12/22/25, when you signed your parole conditions, you agreed to participate in programming as determined by your parole officer. No, your non-compliance violates this condition listed in section number 1 of your parole conditions. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the conditions of parole, Exhibit B, the remand to custody, Exhibit C, the 3/27/26 served notice of parole violation rights, reserved upon updated notice on 4/2/26. Exhibit D, the parole violation report. Exhibit E, the Wheeler Clinic's explored discharge report. Exhibit F, the decision information summary. Exhibit G, the revocation summary. Exhibit H, the GPS agreement. Exhibit I, the 3 misconducts refused to sign. And Exhibit J, the 3 GPS event histories, take off 3. So the GPS event histories is being identified as Exhibit J. Counsel, to confirm, your client now did receive the notice of parole violation, the parole violation report, and all the other things identified for today. All right. I did not receive anything from the defense at this time. Is that correct?
It's the preliminary, yes. He's going to be given some verbal testimony.
Got it.
File the background.
So you don't need any additional time to submit anything. All right, and we don't have any witnesses. So now is the defense's opportunity to respond, to make a short statement, calling witnesses and testify with respect to probable cause and severity of the allegation.
Yes, if I may, the first thing I'd like to address is I know somewhere in the narrative, the parole officer indicated my client had only been out for 3 months. And after doing some mathematical calculations, I believe my client was out for 5 months. I mean, it's 2 months into. There's a difference in my opinion. I just want to put that on the record. And so, Mr. Dorlet, you're under oath. I need to ask my client some preliminary questions before I get into the charges, because it kind of ties in. While you were out in the community, Mr. Dorlet, did you have a job?
Yes, I did.
All right. And what hours were you working and what days of the week, if you recall?
Usually it was a Tuesday through Saturday. I was a outreach representative for Trinity Solar and field marketing. And it's usually between 10 o'clock hour. I'm usually either headed into work or already in the office, and I report to the office later.
Okay. In the course of your job descriptions, you were out in the field. You weren't sitting at a desk all day long, correct?
No.
Okay.
I'm actually in the field, yeah.
Okay. And the reason why I needed some background, obviously, with some of these charges kind of pertain to what was going on while he was working. Under the first under reporting, I do not need my client to testify regarding that. I do know, though, it just stated, and unless you have different evidence than I do, which I don't believe you have, it just indicates that my client was scheduled to report to me with PO. I have no idea when he was given that instruction. Was it via text, via telephone? I have no idea. Because the ongoing reporting is instructed to report, was aware of the instruction, did not report as instructed. Well, number 3, yeah, he didn't report, but I have no idea. And the parole officer is not here for me to question him regarding that. So I am asking that a no finding be made on that one, because I don't think it meets all three prongs of the test. I have no idea. For charge number 2 under GPS, follow-up question to you, Mr. Dorlat. Excuse me, hey, is there somebody else signing? I hear,
They're in the
oh,
hallway.
it's in the hallway, I'm sorry. I
Yeah,
thought somebody-
they're back.
Okay, I'm
there.
sorry, I thought people can log on. I thought someone was, because of my apologies.
Okay.
For GPS, Mr. Dorlat, how many chargers were you given by your parole officer?
I was given one.
One, okay. The first alleged violation occurred on February 1st of 2026. Prior to that first violation, had you been in contact, and if so, how many times with your parole officer that there was an issue with your unit?
Prior to February 1st,
Yes, sir.
I honestly, issues with it? None that I can recall. Yeah, none that I can recall. To be honest with you, be quite candid.
Okay, so do you recall either calling or texting your parole officer at some point that there was an issue with your unit?
Absolutely, I did. I texted him. I sent the text. I said, I'm having issues retaining a charge with my GPS unit, and there was no follow-up, no response.
Okay, and did you mention, if you did, I don't, at any point in time, did you mention to your parole officer that you're out in the field working, and sometimes you did sign your initials on there? It's your responsibility to charge the unit. You're not disputing that, correct?
Yeah, it is my responsibility to charge my unit. I'm fully aware of that. Yeah.
Okay, I know you. And at some point in time, though, you're out in the field, and it was difficult because you would have to drive somewhere where there was an outlet.
Yes. So my job requires me to park my car and walk several blocks. Sometimes I'm probably towards the way other side of town. Like I'm a salesman, a door-to-door salesman, door-to-door solicitor. And I'm out in the field all day. I have to park my car there. My work is tracking my pins. So every pin that I'm dropping, every door that I'm hitting, I have to drop a pin to let the system know that I'm dropping a pin. So they track my timing between the time I go to doors, from door to door, and they're tracking everything. So yeah.
Okay. Issue on February 7th of 2026, the 5:45 to 7:53 p.m. Do you know where you were on that date based on our discussion?
To the best of my recollection, I was in Stamford, Connecticut. I had been visiting my mother that day. She's 76 years old, and I wanted to spend time with her and whatnot because it's getting kind of unfortunately toward that time. So yeah, I was spending time with my mother and family and stuff like that. Yeah.
Okay, and do you recall, if you recall, on February 7th, at some point you realized you didn't have your charger and you attempted to get to your charger? Do you recall that?
Yes, I thought I didn't have my charger. That's correct. Yeah.
Okay, so you went from Stamford, where did you go to?
I went to Waterbury.
To Waterbury, okay.
Where I resided, by the way, for the record.
And where did you end up finding your charger?
It was actually in my car, and I didn't realize that my charger was in my car. All the time I thought that I actually bought that one charger with me, and I swore up and down I bought it with me, and I ended up freaking out because I'm like, well, I got to charge this thing. I noticed that it was, going dead, and I shot back to Waterbury immediately. Went around, looked at my house, searching my whole house. I'm like, where it's usually plugged in a certain place, but for some reason I don't have it. And then later I ended up finding it, and it's actually in the passenger side on the front floor, and unbeknownst to me. So yeah, that's what happened.
All right. The violations on the GPS, Mr. Dorlat, there's 3 different dates, 3 different times on 2/23 to 10:55 a.m. Go ahead.
If I may, real quick, and I'm not trying to be, I don't want to be crass and make it seem like this, but the copy of the conduct report that I have received, I'm not sure if you guys have the same thing, but it's not signed by a supervisor, and it says sent for approval and actually not approved. I'm not sure if you guys have the same evidence, but this is what I just got yesterday. So
That's why I
Just
keep
wanted to
asking
state
the
that.
hearing examiner if I have the same evidence, because I know there was a second notice and things of that nature. May I just give us one moment?
No worries.
This is for the misconduct reports?
Yes, the 223, yes.
That's the one. Can we, may I see that? Yeah, that's it. Should mention. Which, what?
Sorry, stop.
Yeah, that needs a signature. I understand what you're saying. I just want to make sure we were looking at the same, document.
Yeah.
That's for 223. I have one, I believe. That's just for the 223 is where you're seeing that, correct?
Yes, sir.
Okay, I just want to make sure. There's a second note. I want to make sure we all have the same evidence, okay?
No worries. I'm on.
Okay. All right, so we'll note that for the record. He is correct about that, and I do have other ones also. Back to what I was saying about 22326, the 10:55 a.m. to 3:52 p.m. Is that a fair statement? That date, it was a work day, and you were working your 10 to roughly 7 p.m. hours?
Yes.
Okay, and is that one of the days I made reference to where you're out in the field, you're trying to go door to door, make sales, but you also have a obligation to keep your GPS charged?
Yes, sir.
Okay. The 9:49 p.m., I have a question regarding going to misconduct. Let me start with J first, which is Exhibit J, which is the on the last page. It gives the dates and times when there's a violation and when it clears. Okay, so for 223.
Thank you.
It shows a shutdown at 9:49 p.m. Do you have, that's what I say, I don't know if this is cut off. Do you have a time when that clears? No, there's no time, correct?
If I may interject with permission.
Yep.
Examiner, of course. I'm not sure because I don't even know where we're at fully right now, but there is something regarding one of these disciplinary reports which says that I was shut down from 7:23 to 7:40 on one of the dates. And if you examine the chart, it would show that yes, while according to the chart, the GPS was shut down at 7:23. It cleared again at approximately 7:37, I believe, if I'm not mistaken. I believe it might have been for the 2-7.
It's, hold on one second. I know what you're referring to. Give me 1 second.
Okay.
That's for the 2-1.
It could have been maybe the 2-1.
Yeah, so the way I'm reading this, Mr. Dorlat, you're correct. It's just listed. I think he can't speak for him because he's not here. So it looks like the evidence I have, which is J, I know yours is not lettered, on 2/1/26, it's shut down, as you indicated. It was only a 14-minute shutdown, 7:23 to 7:37, okay?
Yeah.
And then it looks like it clears at 7:38.
Sounds about right.
Okay.
I'm not looking at it right
And
now.
then there is and I think you beat me to this part of it here, because after I went over the other day, I wanted to get back to this. It looks like the violation from 10:40 p.m. and then it clears at 10:45. So I think I know what you're trying to say. It was not a continuous violation for that many hours. It was 12 minutes, 14 minutes, correct?
Right. Yes, yes, sir.
Okay. Yeah, I have that in my notes. I wanted to cover the end date for the 9/49 one where I don't have the shutdown for that.
No worries.
Regarding this program participation, this is the one that
You're kind of, I'm not sure if you can hear me, but you're kind of going in and out a little bit.
yeah, we can hear this. This is modern technology with the video equipment. If at any point in time, just raise your, I don't know what you're hearing. I hear. So if there's a lapse, just raise your hand. That's the only way I'm
No
gonna know.
worries. No worries, no worries.
Okay. Regarding the last charge on the program participation, Mr. Dorlat, you were required to do 26 classes. You were aware of that, correct? All right.
Yes, sir. Yes, sir.
And it appears you were present for 10 of them. And then there was some unexcused absence, which led to your discharge, correct? Is that a fair statement?
Yes, sir.
Okay. And the last unexcused absence, according to the evidence I have, was 3/5/26. And then this discharge report was generated approximately 12 days later on 3/17/26.
To the best of my recollection, yes.
Okay. From after 3/5, on 3/5, did you know you were discharged on that day? Let me ask you that first.
I did not.
Okay, so after 3/5, did you attempt to attend additional classes after that?
I did.
Okay, and could you let the hearing examiner know what occurred as far as you going to class?
So I attempted to go to class as usual, and I was told that, well, I actually looked on the sign-in sheet to go sign my name because there's a check-in process, and my name wasn't there. So I spoke with one of the facilitators, and I'm like, well, my name isn't here, so I'm just trying to figure out what's going on here. And she indicated after conducting some research through electronic records, she discovered that I had been discharged, and that was pretty much for that. And there was no, from what I can recall, no real indication as to why I was discharged. And I was kind of a little puzzled as well.
Okay, so you did make an attempt even after the last unexcused absence. So you're allowed, I believe it's 3 misses, correct? The fourth one, they remove you.
I believe so, yeah.
Okay, so there was an unexcused absence where you had a doctor's appointment, correct?
Yes.
Okay, did you make any attempts to get, not verbally tell them, but did you make any attempts to get a doctor note to the facilitator to let them know you had a doctor's appointment?
What happened was I actually sent the doctor's note to the facilitator through, and the facilitator's at Weller Clinic. Her name is Zay. I can't recall.
I have all
her
that
name.
information. Give the testimony as you recall it, and I can add to that afterwards.
Okay, so I attempted to send it to the number that I had for her. Is that what you're looking to know? Because yes, I took a photo of the doctor's note. I sent it through text. And at the time, I believed that she could receive text messages through that number. So.
Okay, so if I may, for the record, I'm not going to put her name on the record. I'm just going to put her initials. She's a worker there, and the initials are SH. My social worker spoke to SH yesterday as I stood by as she's speaking to the facilitator. My client did fax a doctor's note. Had that doctor's note been approved, it would have been an excused absence. It wouldn't have been removed from the program. The facilitator, and this information is to my client, did pass on the note to her supervisor, and she wouldn't elaborate as to why it was approved as a excused absence, although he had a doctor's appointment. My client, his testimony, I had to verify, which I did before I put things on the record. the social worker, my social spoke to SH yesterday. She did verify my client used his, as he said, he tried via text, but that phone did not receive text. He used his personal email, and she did verify yesterday that she did receive an email from Mr. Dorla with a doctor's, which he did. Now, to the part of, I understand certain amount of misses and then you're discharged, but in this evidence that was submitted by the parole officer discharge report, the 10 classes that my client did attend, and I think it's important to know what that, not parole officer is not there in class with my client, obviously, but what they wrote about Mr. Dorlak kind of speaks volumes as to what he was doing and taking full advantage of the program. So I'm referring specifically to Exhibit E. And throughout the month when present, client was alert and cooperative, completed check-in without issues, participated appropriately in group discussion, denied any police contact, impermissible contact, or abuse of substances. Jump on to the next paragraph. During the sessions he attended, client demonstrated an understanding of timeout through reflective responses and discussion, indicating comprehension of its purpose as a regulation of safety intervention rather than avoidance. Jumping to the next one. Mr. Dorlet participated actively and provided reflective answers regarding accountability, demonstrating understanding that responsibility requires behavioral change rather than explanation within the context of the Explore program. And kind of what I was saying, during the interventions, when he was there, he did participate, engaged with the core Explore interventions, focused on accountability and self-regulation. His documented responses indicate emergence alignment with the program objectives of increasing emotional awareness, strengthening behavioral restraints, and reducing reliance and coercive or reactive responses under stress. So when he was there, he was active and participating. I know you've seen it here numerous times where the clients are in these programs and they're not doing anything. That's not the case with Mr. Dorlet. This isn't Mr. Dorlet's testimony. It's not his parole officers. It's coming from the group facilitator. And it did indicate he was consistently on time, cooperative. That's under the comments and recommendations, consistently on time and cooperative during all attended group sessions. No behavioral changes to report at this time. Client did report coping skills to assess with self-control and stop and think. If that's a client, refer back to referral source. So I understand he was discharged, but his behavior in that program wasn't because he wasn't cooperating, because he wasn't engaging. It was for the unexcused absence. And he was hoping that with a doctor's note, it wouldn't have led to that. I understand he was discharged. We're not disputing that. But I just wanted to give you some background how well my client was engaged in his treatment. He did take it serious. And once again, this is coming from the facilitator. So I did explain to my client the preliminary hearing procedure regarding the probable cause, and the second prong is so there's that my client is being incarcerated pending further revocation hearing. I am asking you to consider strongly to look at the second part. Obviously, there are violations here. We're not disputing that part of it, but by giving you some background, as an individual who was out, I understand he was on five months. He did have a job, gave you the nature of his employment. As far as the shutdowns, he's aware of his responsibility, his charge. We're all familiar with the solar people coming and knock door to door, Mr. Dorley. So we know you park your car, you cover an entire block, and then you got to come back to the vehicle. So he was working, he was trying. And as far as this program participation, I mean, I can't get a better written report from the facilitator that Mr. Dorlet had, with the understanding he was discharged for the unexcused absence, not for his participation. But it speaks volume, in my opinion, as to what they wrote as to how well he was participating. Go ahead, Mr. Dorlet.
Just a couple things that I wanted to touch up on as well is I'm not sure if you recall the issue that as far as that I come to learn regarding the extension cord.
Yes. Once you put it on the record, you could go ahead.
Okay, so ma'am, so there was one time where Officer Rodriguez actually conducted a home visit at my apartment, and he was accompanied by Officer Montoya, and through that process, I learned that I guess there's some sort of issue when the charger gets plugged to an extension cord, because I was having a discussion with the officer, parole officer Rodriguez, about the charging and whatnot, and he said that he was striking me up. So Montoya interjected, and I mean, I never had a conversation with this other officer, Montoya, in my life, you know, and she was like, it just looked like she was trying to helpful and be noble about it. She asked me, she says, how are you plugging up? How are you charging? I said, miss, I thought it was a weird question, because I'm like, I just take the two components and I plug them together and I plug it in. And she's like, well, no, are you plugging to an extension cord? Are you plugging to the wall? And I'm like, hold on. The light bulb went off in my head. I'm like, what do you mean? And I walked right over to the power surge stick that was plugged into the wall, and I held it up to her. My charger was still plugged to it. And she said, that's your problem right there. And I'm like, what? She said, yeah, that's your problem. You can't plug to an extension cord. This has never been explained to me. I had no formal knowledge of this. And I'm like, you know, I came home, I've accomplished a lot of things. I'm a volunteer recovery coach at CCAR, Connecticut Community for Addiction Recovery. I've got a full-time job, even work part-time for a labor company called People Ready when on my days off, just to keep myself busy and active. You know, and I've completed all the other programs that have been required of me to do by the board, timely and successfully, and have good references. Even prior to being released from my incarceration, during my last incarceration, I know there's evidence and information regarding in this package, the list that it clearly states that, you know, I'm active in trying to change. You know, I'm trying to make changes in my life. There's some programs that was listed that I did voluntarily prior to, like, without anybody actually saying these are actual requirements for you to do this program. It's to keep myself positively busy, just striving. I have financed a vehicle for the first time in my life since I've been home. And I've just been working effortlessly to make change and, you know, become someone who actually lives that pro-social lifestyle. So I just wanted to just kind of put that out.
Thank you, Mr. Lee.
Thank you.
Anything?
I don't have anything else to add. As I said, this is the preliminary hearing, so I'm kind of limited. I did explain that to my client. So I don't have anything else to add at this time.
Let's take a moment and then I'm gonna announce my finding. The testimony presented today, and we are establishing probable cause. Mr. Durlett, so I am going to announce my findings with respect to probable cause. On charge number 1, the condition of reporting, I'm making a no finding as the state fails to submit sufficient evidence in support of that charge, as the elements are not met. On charge number 2, I am making a finding of probable cause for the condition of GPS based on the evidence presented in states exhibits A, D, I, A, D, H. I'm only using the two that are dated 2/1 and 2/7 as per the argument from the defense that the other one was not approved. And then.
I'm sorry, can we charge to GPS made a finding on 2? Could you just give me?
No, I'm making a finding on all of them, except I'm only using the 2 exhibit Is.
Exhibit, okay.
That the ones dated 2/1 and 2/7.
Understood.
So A, D, H, I, and J. And I'm also making a finding of probable cause for charge number 3, the condition of program participation based on the evidence submitted in states exhibits A, D, and E. With that, Mr. Durla, I am finding that the act is serious enough to warrant revocation, and I've also determined that you should be detained while you await that revocation hearing. So we'll notify the records facility as well as your charging officer of the decision from today. So what happens next, Mr. Durla, is we're going to get you back in for a revocation hearing in the next few weeks. At that hearing, myself or another hearing examiner will determine whether you violated the conditions of your parole. And if so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanction should be imposed. So that does conclude today's hearing.
Yes, and I just have one thing. I'll reach out to you once I get a date. As I explained to you, one other issue that I want to deal with. I did get a call. I'm just going to use her initials. I believe it's NC yesterday.
Yeah.
Do you
Yeah.
want me to add then? I have to make it part of the record. If you want me to add the name to that witness list, or do you want to keep her off? That's your call.
Yes.
Okay. And could you just state for the record, so on that sheet, the client list, witness list, we want to add a name to it, so all parties are on notice that we want to add a name to the witness list.
So you're gonna submit a witness list?
No, my client submitted on there. We just want to add one name to it.
Okay. But you're gonna call all these people for the revocation hearing, because I think that we should probably get something. Can you send us email specifically?
If we, after, yes, I just want to add it, just like in criminal court, we have a list that doesn't necessarily mean they're going to be called. But I want to add the name, so it's fair to all parties. As I explained to Mr. Odorla, I have to put everyone on notice. Whether we call it then is another story, but I do want to add that name. Yes. So Mr. Odorla, could you put her name on the rec, just her name?
Nancy Cordova.
All right. As soon as I get the date, I'll be in touch with you. Ms. Lopes will be in touch with you before me, and then you and I are going to have a further discussion based on just the two charges that are left and how we're going to go about that. All right. I'll talk to you soon.
So this concludes the hearing for Mr. Dorlett, and number 306054. We'll see you soon, okay, Mr. Dorlett?
Thank you. Have a good one. Hello.
Hi, sorry, Officer Esposito, I am unfortunately super behind. Yeah, so we haven't made it to, I'm sorry, Mr. Stearns, one moment. We haven't made it to, I don't even know where this. Wow, I'm so behind. Can I shoot you an email to let you know to log in?
How long do you anticipate it to be?
So I have one more here at New Haven. I have to go to Cebulski after this, and then I'd go to court again for Mr. Krajewski. So I can't even tell you what time. I would hope by 1, the absolute latest. I'm hoping.
Okay.
So I can, if you want to stay logged on, you can just turn your camera off and mute and listen if you want to do so, or I'll send you an email, whatever works best.
You can just send me an email.
Okay. All right. Perfect. Thank you.
Thank you.
Attorney Dean, are you with us?
Hi.
Thank you. We are going to get started. Okay, Mr. Stearns.
Okay.
All right. So good afternoon. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Garrett Stearns, inmate number 334640. Today is Wednesday, April 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Certainly. Garrett Alexander Stearns, 334640.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Stearns.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state and IU has a responsibility to prove the allegations by a preponderance of evidence, and that is the better weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision, And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Stearns, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence that you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
I do not.
All right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney. Counsel is here present for you. You also have the right to review the evidence. Sorry, you have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. To understand these rights, and are you ready to go forward?
Yes, I am.
So we are now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So in charge number 1, the condition of absconder, the charging officer reported that on 10/11/2025, the offender did not return to the halfway house, which is his only parole-approved residence. The offender has failed to contact parole, and his whereabouts are currently unknown. Charge number 2, the condition of behavioral management program, the charging officer reported that on 6/2/2025, the offender attended an intake for Explore and was instructed to attend every Tuesday at 11:30 a.m. starting on 6/10/25. On 9/16/25, 9/23/25, 10/14/25, and 10/21/25, the offender did not attend Explore as required. Subsequently, on 10/21/25, the offender was negatively discharged due to violating attendance rules. And on charge number 3, the condition of halfway house placement, the charging officer reported that on 10/11/2025, the offender failed to return to the halfway house from the community past 5:30 p.m. return time. The offender failed to contact his parole officer or halfway house staff, which is in violation of halfway house agreement, stating I will return to the halfway house from community pass at my scheduled return time. If I'm unable to do so, I will call program staff to explain why I am expected to be late and receive a new return time. The offender's whereabouts in the community remain unknown. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the conditions of parole, Exhibit B, the remand to custody, Exhibit C, the notice of parole violation, Exhibit D, the parole violation report, Exhibit E, the halfway house agreement, Exhibit F, the halfway house incident report, Exhibit G, the misconduct, and Exhibit H, the Explore report. In addition, the state did file an addendum to the parole violation report on February 18, 2026 that states that on 11/13/2025, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On 2/17/26, FIU and Torrington PT apprehended the offender out of residence in the city of Torrington. Counsel, to confirm, you and your client did receive a notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have. Thank you.
Great. And I did receive exhibits from the defense. So I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, a character letter from Erin Hamill. Exhibit 3, a character letter from Sheena Marie Woodall and Luana Fisher, licensed therapeutic foster parents. And Exhibit 4, the employment letter from Lillian Echeverria, store manager at Monroe Auto Service and Tire Center. Counsel, do you need time to submit any other documents for today?
We do not. Thank you.
Thank you. And there are no witnesses. So at this time, it is the defense's opportunity to call me witnesses, present evidence, and speak to any of the evidence submitted. So counsel?
Yes, just very briefly, I would note as to the behavioral management charge, Mr. Stearns was actively engaged in Explore. I think that he had done about 14 out of the 26 sessions. So my understanding is he was about halfway through. He was discharged due to attendance, but I did just want to note that he was engaged and actively participating while he was there. And then we would at the appropriate time like to speak about his background and history. Thank you.
So I'm going to announce my findings at this time, Mr. Stern. I did listen to the testimony. I reviewed all the evidence submitted. With that, I am going to find that you violated charge number 1, the condition of absconder, based on the evidence presented in States Exhibits A, D, and F. I'm also finding you violated the condition of behavioral management program, which is charge number 2, based on the evidence presented in States Exhibits A, D, G, and H. And on charge number 3, the condition of halfway house placement, I'm also finding you violated that condition based on the evidence presented in States Exhibits A, D, and F. So it does conclude the fact-finding portion of this hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So, counsel?
Yes, thank you. Mr. Stearns is 40 years old, born and raised in New Milford, Connecticut. He received support in the community from his mom, brother, grandfather, and both of his uncles. His grandfather lives in Connecticut. The rest of his family are based down south in the Carolinas and West Virginia. My client also has a couple close friends in the community, and he does have one 8-year-old daughter as well who resides in Louisiana. My client most recently on supervision was utilizing Chase Center in Waterbury. He was employed full-time as the meat supervisor at Price Right in Waterbury for about 4 months. He participated, as we had noted, in the Explore program and had done a number of those classes. Since being incarcerated on this remand, he's been on the wait list for a job at New Haven. He's had no disciplinary issues, no tickets since he's been back in custody. Upon reinstatement of his parole, he would like to go back to the Waterbury jurisdiction for a halfway house. He eventually would like to obtain a sponsor in the community and find independent housing. He is hoping to enroll in a counseling program. He would like to one day become a counselor himself to give back to others. He does have 2 employment opportunities waiting for him. The first, as you saw from the letter, is from the Monroe Auto Services, and then the second is with Stop and Shop out of Waterbury. And he also is open to any sort of treatment that's being recommended by parole, including the Explore program and also individual therapy. I am asking that you consider a sanction not to exceed 3 months for Mr. Stearns. He has been incarcerated since February of this year, and while in the community, he was treatment compliant, and this isn't a situation where he picked up a new case or anything of that nature. Mr. Stearns, is there anything I didn't cover about, the positive things you were doing that you want to put on the record at this time, or anything that you would like to say?
I'd just like to say that, Ms. Dean, thank you very much. I think that you covered, everything eloquently. I simply put, I made a mistake. Whenever the board sees fit or whatever sanction is given, I'm just looking forward to getting back to not restarting, but continuing where I left off in a positive nature and note for my life, obtaining employment, financially being stable again, getting my own place. I will unfortunately need the services of a halfway house because I do not have my own sponsor currently. But I'm just looking to, like I said, not restart, but just getting my life back on track again as it was. I did unfortunately make the error of leaving the halfway house. I take full accountability for that for myself. But to be honest, at 40 years of age, it's sad to say, I'm a little embarrassed to say that I really am getting too old for this type of behavior and to be in these type of circumstances. And I'm really ready to take hold of my life and be accountable and responsible for everything that happens and really just put the focus on myself.
Thank you.
Thank you, Mr. Stearns. Anything further, counsel?
No, thank you very much.
I'll just take a moment and then I'll announce my recommendation. So again, I've listened to the testimony presented today. I've reviewed all the evidence submitted. Just want to note on the record, Mr. Stern, this is your second violation on special parole, and you were only on supervision for about 5 months before you absconded, and you were unaccountable for about 4 months. Absconder status. Polk Community Services did recommend a 12-month sanction. That I'm going to recommend Mr. Stearns that you revoked and that you serve an approximate 5-month period of confinement as a sanction. That's with the reparole date of July 17th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with victim BM, JB, and TC, a general no contact with TS, problem sexual behavior treatment, no operation of a motor vehicle without parole officer's permission, and halfway house placement in Waterbury. So that does conclude today's hearing. What happens next, Mr. Stern, is that my recommendation is going to go to the board next week on April 23rd. On that date, the board can do 3 things. They can lessen that recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of time, you'll be brought back for another hearing, okay? Before any of the longer is imposed, you'll answer their questions, concerns before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
I do not.
So that concludes the revocation hearing for Garrett Simmons, inmate number 334-640. Good luck to you, Mr. Stearns. Thank you, Attorney Dean.
Yes,
Thank you very much.
Thank you.
Have a good day.
You too. Good afternoon. Thank you. Sorry for being late.
Good afternoon.
Good afternoon, Mr. Rogers. We're going to get started, okay?
Yes.
All right. This is going. All right. So good afternoon. I'm parole officer Cisello, and I'm the hearing examiner for the Board of Partisan Paroles. This is a revocation hearing concerning Gary Rogers, inmate number 161910. Today is Wednesday, April 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Cybulski Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Gary Rogers, 161910.
Thank you, Mr. Rogers. So this is a public hearing, and public access to this hearing is available via video live stream. So we are going to go over the purpose for today's hearing. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to the panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Rogers, can you please raise your right hand?
Yeah.
You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Yeah, you can put your hand down. Thank you. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present all relevant testimony. You'll have, just an opportunity to present all relevant testimony and any relevant documents. After considering all of the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights and we're going to review them now. So the first one is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Mr. Rogers, were you informed that an attorney could represent you at today's hearing?
Yeah, I don't want an attorney.
You don't want, so you're willing to move forward today without any legal representation?
No, I want to move forward. I don't need no attorney.
Okay, no problem. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. And you were able to review that information?
Yes.
Okay, great.
I reviewed it.
You reviewed it. Perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yeah, I just go forward.
Okay, so we're going to review the charges now that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of reporting, the charging officer reported that on 10/1/2025, you failed to report to parole as instructed. On charge number 2, the condition of obedience to the law, the charging officer reported that on 2/9/2026, you reported to New Haven District Office during a search of your persons, a white rock-like substance fell out of your pocket. New Haven Police Department responded and tested the substance. The substance was determined to be crack cocaine. You were charged with 21A-279A, possession of narcotics. The report date is 2/13/2026. And charge number 3, the condition of drugs, the charging officer reported that on 12/10/2025, you tested positive for cocaine at the Connection Reach program. You signed documentation admitting use of cocaine. On 1/7/2026, you tested positive for cocaine. You signed a voluntary admission. On 2/2/2026, you tested positive for cocaine at the Connection Reach program. You signed documentation admitting to use of cocaine. And on 2/9/2026, you reported to the New Haven District Office as instructed. During a search of your person, crack cocaine fell out of your pocket. New Haven Police Department responded and tested the substance. The substance was determined to be crack cocaine. You were charged with 21A-279A, possession of narcotics. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the conditions of parole, Exhibit B, the remand to custody, Exhibit C, the notice of parole violation, 2 sets, Exhibit D, the notice of parolee rights, Exhibit E, parole violation report, Exhibit F, voluntary admission from DOC, Exhibit G, the voluntary admission from the Connection Reach program, Exhibit H, the offender misconduct, Exhibit I, the letter from MCCA, Exhibit J, the email from MCCA, Exhibit K, the state of Connecticut residential substance use screening referral, Exhibit L, the email to App Foundation, Exhibit N, the App inpatient treatment denial letter, Exhibit O, that New Haven PD misdemeanor summons, case number 26-005132, Exhibit P, the decision information summary, Exhibit Q, the revocation summaries, Exhibit R, the state of Connecticut judicial branch pending case detail, and Exhibit S, the New Haven Police Department report, and Exhibit T, the REACH program contract. In addition, the state did file an addendum to the parole violation report on March 9th, 2026 that states that on March 5th, 2026, Mr. Rogers appeared in New Haven court at GA 23 under docket ending in 429S, at which time the charge of possession of a controlled substance was disposed of as he received a sentence of 11 months jail, execution suspended, followed by 1 year of conditional discharge. One more time to confirm, Mr. Rogers, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
And you did review all the evidence that was submitted?
Yes.
Perfect. I did not receive any documents from you at this time. Do you need time to submit any evidence for your own behalf?
No, the only one, the charge, where it said, I was in a reach bed and I didn't report, I overslept, and she punished me. She changed me from once a month back to once a week. So I don't know why I was getting charged with that when I was punished for that already. I was in a reach bed. I overslept. I didn't report that day. And then I called her and she said, well, instead of you coming in once a month, now I want you to come in once a week. And that's what I did. So I was punished for that. And then the other parts,
had dirty urine. I did cocaine.
Okay.
Yeah, it's true. It's true.
Thank you for that. I do appreciate your statements. I am going to, anything additional towards the charges, you don't have to say anything. It is the state's burden to prove the case. But I do appreciate your statement so far. Anything before I do make my findings?
No, it's just that, you know, I got high, I messed up, and, you know.
Understood. So I am gonna announce my findings then, okay, Mr. Rogers?
Yeah,
So on charge number 1, I'm gonna make a finding that you violated the condition of reporting based on your admission in today's hearing that you overslept for that appointment.
yeah,
And on charge number 2, I'm finding you violated the condition of obedience to the law based on your conviction of the possession of controlled substance when you received that 11-month jail sentence, execution suspended, followed by 1 year of conditional discharge. In addition, the evidence that supports that charge is State's Exhibits A, E, R, and S. And I'm also finding that you violated the condition of drugs. That's charge number 3 based on your admission in today's hearing, as well as State's Exhibits A, E, F, G, H, and S. So that does conclude the fact-finding portion. Before I make my recommendation, you'll be able to provide information about your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So Mr. Rogers, any thoughts about your plans for release? Any sobriety plans? Any housing plans?
yeah, I wanna, yeah, so, if you could release me back to the halfway house in New Haven so I could, start my, I already been going to meetings in here. And, I want to get my, disability, going because, my medical condition is my heart, condition. And I had used for, I had, severe pain in my legs. And now they got me back on my right medications. So I would like to go back to the Walter Brooks house where I left there and went to the REACH program. I'd like to go back there for the last couple of months. I had to get myself together so I could get a place to stay so I won't have to go straight to the street. So if you could release me back to the Walter Brooks house in New Haven residential, I'd be much appreciated. I made a mistake, you know. I didn't scam her or nothing this time. I just I used a little drugs, and that was a mistake.
Okay. Well, thank you for your statement. I really do appreciate it. So I have reviewed all the evidence submitted. I've listened to your testimony today, Mr. Rogers. I do want to note a few things for the record, that this is your 3rd time violating the special parole term.
Yes.
Out for about 8 months I have since your last release and when you were remanded. It looks like parole was actually working with you because you did receive 2 misconducts, but you were also referred to treatments in the community, MCCA and the App Foundation. So they were trying to get you some help out there, right?
Yes, ma'am.
Parole and Community Services did recommend to revoke your parole with no new re-parole date. So I just want to put that on record also. So Mr. Rogers, with that, I am gonna recommend your parole be revoked with no re-parole date, which is an approximate 5-month period of confinement as a sanction. I have as of today, or it's set, so your special parole does end July 18th. So I'm going to present this to the board next week on April 23rd. In the event the board decides to lessen that recommendation, because they can do so, I'm going to also recommend that there's no, the following conditions: no consumption of alcoholic beverages, mental health evaluation treatment as deemed necessary, and halfway house placement. So what happens, Mr. Rogers, is that I'm going to bring this to the board next Thursday. On that date, they can lower if they choose to do so. I'm going to pick any date between Thursday and your end of special parole in July, or they can just adopt the recommendation. Okay.
So what is your recommendation?
My recommendation is no new re-parole days. So going to the end of your special parole term, which is July 18th, 2026. It's a 5-month sanction. Yeah, it's a 5-month sanction.
So I'm just gonna do the rest of my time. Is that all you're telling me?
Well, that's my recommendation, but the board next week can lower it.
Yeah, but they usually go with your recommendation. So
Okay.
thank you very much. Yeah.
Thank you for talking to me. Well,
Yeah,
if anything's possible, I'm gonna write that you would like some secure transition time, and it'll be up to them. And we'll send you a letter in the mail a month after, not a month, about a week after next week's hearing with what their final decision is, okay? All right, thank you. This concludes the revocation hearing for Gary Rogers, inmate number 161910. Good luck to you, Mr. Rogers. Good morning, thank you. It's afternoon. I'm sorry I'm late.
Hello.
Hi, Mr. Oh boy, Krajewski?
Yes, very good.
Perfect.
Krajewski or Krajewski?
Wait, what is the other one? What'd you say?
Krajewski. Krajewski?
Yeah.
That's
Krajewski?
Polish. Yeah, Krajewski's Polish, Krajewski's English, you know what I mean?
Yeah, we'll see how it goes. So I'm just waiting, your Officer Esposito was logged in already, but I am super behind at this point, so, we're just gonna wait for her to log back in and then we'll get started, okay?
Okay,
Thank you.
you're welcome. Very busy day.
Yeah, I was doing really well until about 11 o'clock and then I just got behind, unfortunately.
It happens.
That's happened. Sorry, Kristen, are you with us?
I am.
Officer Esposito just wrote me back saying she's trying to open Teams and it's not working. Can you maybe, what do you say, send her a pin? Send her a ping?
Yeah, I've been trying to ping her and it just goes unanswered.
Okay.
So as long as Teams is, I would have her quit and restart Teams. But as long as it's open, she should be able to get my ping.
Hello?
Hi, we can hear you. Perfect. Sorry about that, and thank you for being able to log back in. I appreciate it.
Okay, sorry, I had to, I don't know how to, all right, I don't know how to switch that.
That's okay. Are you able to turn your camera on by any chance?
On? I can, but I'm in my car, so I would have to.
You're not driving.
Okay, now, yeah. No, I'm not driving.
Okay, all right. All right, perfect. Thank you so much. So, good afternoon. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Michael. Yeah, I'm not going to get this. Krajewski. I mean, yeah, I can do the English way, like you said. Michael Krajewski, inmate number 187569. Today is Wednesday, April 15th, 2026. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
187569,
And can you state your full name for the record too, please?
Michael Douglas Krajewski.
Thank you. So this is a public hearing. Public access to this hearing is available via video live stream. Person this morning is your charging officer. Can you please identify yourself for the record?
Parole Officer Esposito, Norwich District Office.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you, placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. I do want you to know, Mr. Krajewski, you also have the option to waive today's preliminary hearing conceding to probable cause. That's due to you having new criminal charges that are pending. So what that means is that today's hearing would be concluded, and once the pending charges are settled in court, we'll be notified by Parole and Community Services, and then we'll be able to schedule you for a revocation hearing. So just to see, Mr. Krajewski, do you want to continue with today's hearing?
Yes, I do.
Okay. So you should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Krajewski and Officer Esposito, can you both please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
I do.
I do.
Perfect. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I'll inform you my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I'm good. Thank you.
So you have important rights, and we're going to review them now. The first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Mr. Krajewski, were you informed that an attorney could represent you at today's hearing?
Yes.
And do you intend to seek counsel for today's hearing?
No.
So you're willing to move forward today without legal representation?
Yes.
Okay. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. Did you receive the evidence package?
I did.
You did receive it. Okay. Were you able to?
Evidence, a package, I got something from parole. That's just saying that, like my GPS battery was dead. Is that part like that? Is that the package you're talking about?
This is my packet of your evidence. So it'd be a packet of the different paperwork that Officer Esposito has provided to support the charges against you. So there's, I don't know, GPS.
I got that one. I did have that one. Yes, I got that. That's the packet. Yes, I did receive it.
Did you receive it? When did you receive it? I just want to confirm.
A couple of days ago, I believe, or.
In the mail?
Yes.
Okay.
No, it got delivered. Yeah, it was in the mail, but the CO delivered it to the door. I mean, that's how it's procedure. That's how it works. I don't know. I mean.
So you were able to review all of the evidence provided as well as the notice of parole violation and the parole violation report?
Yes, yes.
Okay, all right, perfect. You also have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand all these rights, and are you ready to move forward?
Yes.
We will now review the charges that the state, your parole officer is bringing against you and the information underlying each charge. So Officer Esposito, can you please review the charges for us, starting with number 1, condition of GPS?
Sure. Charge number 1, GPS. On the following dates, your GPS monitoring device was shut down due to you not charging your GPS. On 1/14/26, 1/18/26, 2/17/26, 2/26/26, 3/6/26, 3/14/26, 3/20/26, and 3/23/26. Based on your actions, you are in violation of special parole condition release direction. Number 2, obey all laws. Charge number 2, obedience to the law. On 9/3/25, you were operating in the town of Connecticut. You were driving recklessly by screeching your tires and speeding erratically when you were stopped by Plainfield Police Department. You were arrested for operating a motor vehicle without insurance, operating with a suspended license, and reckless driving. Based on your actions, you were in violation of special parole condition, obey all laws. On 9/28/25, you were operating a motor vehicle in Haverhill, Massachusetts. You observed driving over the line and that the left tires were in the center travel lane and the right tires were in the right travel lane. A motor vehicle stop was initiated by Massachusetts State Police. You were given a citation for marked lanes violation and given a warning for registered motor vehicle violation. You were arrested on another warrant for larceny over 1,200. Based on your actions, you were in violation of special parole condition, obey all laws. On 9/28/25, the victims reported that you were given $3,000 in cash for a down payment toward materials for a chimney replacement. You failed to return the funds and materials as agreed upon and agreed to partially refund and return the purchased materials. You refused to fulfill your obligations to the victims. You failed to return the money and materials to the victims. Based on your actions, a warrant was issued for your arrest for larceny over 1,200. You were subsequently arrested on 9/28/25 during a traffic stop in another incident. Based on your actions, you were in violation of special parole condition, obey all laws. Travel. Charge number 3, on 9/28/25, you were arrested in the state of Massachusetts. You were not given permission to be out of the state of Connecticut. Based on your actions, you were in violation of special parole condition, obey all laws. On 4/25/24, you were in the state of Massachusetts at the victim's residence. You were not given permission to travel to the state of Massachusetts. Based on your actions, you were in violation of special parole condition, obey all laws. Charge number 4, no driving. On 3/27/26 at 2:24 p.m., you were observed operating a motor vehicle in the town of Killingly, Connecticut. You did not have permission to operate a motor vehicle. Based on your actions, you were in violation of special parole condition, no driving.
Thank you. You've also submitted evidence in support of the case. Can you identify the evidence for us, please?
I'm sure. Exhibit A, signed statement of understanding and agreement of conditions of parole. Exhibit B, remand to custody order. Exhibit C, violation notice of parole violation. Exhibit D, parole violation report. Exhibit E, GPS monitoring report. Exhibit F, Massachusetts State Police report. Exhibit G, Plainfield Police report. Exhibit H, GPS monitoring agreement. Exhibit I, misconducts. Exhibit J, decision information summary. Exhibit K, photos. Exhibit L, Dudley District Court email, and Exhibit M, Dudley police narrative.
Thank you. And Mr. Krajewski, just to one more time confirm, you did receive all of these documents identified for today, as well as the notice of parole violation, and you were able to review all that information, correct?
Yes, ma'am.
All right, and I did not receive anything from you at this time. Do you need any time to submit any evidence for your own behalf?
I don't have, no, I don't.
No problem. So we don't have any witnesses today. So at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Esposito, would you like to make any statements?
Yes, I also want to clarify for charge number 2. On 9/28/25, he was arrested on the warrant from Massachusetts for the offense for the larceny over 1,200, which the actual offense date for that offense was on 4/25/24, when they actually 8/15/24, when the victims actually reported the incident with the larceny 1,200 case. So just clarifying that. Also, I just want to say that, you know, Mr. Krajewski, he's been on parole, special parole for like considering a long time now, about 7 years. You know, this isn't his first incident. I'm sorry, what is it, 8?
Yes.
It's
8.
and, you know, Mr. Krajewski, like, he has no other previous violations, but he also has had other issues driving in the past. This is at least the second incident. There was another incident in 2023 where he was operating a motorcycle, which, you know, he got into a pretty serious accident operating that motorcycle. You know, he's had issues with his license here and there in Massachusetts and in Connecticut. Also, the underlying offense is a pretty serious driving charge. You know, he has a misconduct with a motor vehicle and evading, where someone actually, you know, passed away from this offense. So, you know, we try to give him the opportunity in the community since September, after, you know, these incidents occurred, and just restrict him on GPS and to not be driving, and then he's continuing to drive. So that's really all I want to say about like the severity of the offense, you know, in the current parole violation charges.
Thank you.
Yeah.
So Mr. Krajewski, this is now your opportunity to respond to the parole violation charges against you. However, I do want you to remember that you do have the right to remain silent if you choose to do so. So at this time, would you like to testify regarding your case?
Yes, I would, you know, basically I would like to say just about the few things about my license being suspended. My license was never suspended. My license has been valid since I got my driver's license back in 2019. I had to take, and I paid Massachusetts over $1,700. I have a signed written statement of the owner of the bricks and the materials in my truck right now that I handed him $3,000 back. And I have those materials right now on my property that we squared that up. I have that written statement, and that you know, him and his son come to my property with his vehicle and his trailer with the materials. At that time, I gave him $3,000, and we both began unloading materials, which I have them in my possession right now. I have the insurance companies, all the things saying my insurance on my truck never relapsed. I went from direct insurance to progressive. There is no relapse in it. And as you know, I went to court yesterday, well, the day before, and I pled to the Alpha Delta thing. From the fine of the only thing at a high rate of speed, screwing my tires, I didn't exceed more than 15 miles an hour, but my tires did spin, but I didn't exceed over 15 miles an hour. I was driving in Dayville, Connecticut, the time before I was going to work. I was at McDonald's at the drive-thru. Yes, I was. I'm going to take full responsibility for that. I was driving, and I was told several times not to. And there's, you know, I can't. That is, you know, I shouldn't have been driving. I was. I have nothing to. I can't say, you know.
the charges, you know, about the, you know, one of those, I do believe the GPS, my charger dying. I don't know about the 8 times, if it went dead 8 times, if that's what it said, then if that's what it is. I don't know. Maybe I didn't feel it vibrating. I looked and I don't know. I don't know. If it was died 8 times, it died 8 times. Other than that, I can certainly say that, it's been 8 years. I've been on special parole. I've completed all my programs. I've, you know, besides, you know, of the driving thing, the one thing about it, they keep saying I was driving under suspension without a driver's license. That is 100% not true. My license was never suspended, and you could probably see that right there from that computer, that I was never suspended, and my insurance never relapsed. I've always carried insurance. I have a little bit of time left. I think it's 14 special parole, and this is definitely a wake-up call. If I could lock myself at home right now, I'd never walk out. Until then, I would. It's definitely a wake-up call, and I can't, you know, I was warned several times not to drive. Whether the circumstances I had to get, whatever the circumstances, I was told not to drive, and I did. So, you know, I don't need I don't need a lawyer to say that, you know, that, I mean, I'm taking full responsibility for that, and I get it. So, you know, I understand, I just apologize, and I guess we'll have to move. And like I said, I've locked myself at home now, and I wouldn't come out until I would never drive again, that's for sure. It's definitely a wake-up call.
Yeah, and sorry, I didn't mean to cut you off. You can, anything additional, go ahead.
No, that's it. I can just say that, you know, Ms. Esposito has been a great parole officer, and she gave me many chances, and she's very fair. I'd just like to say that.
Thank you. I do appreciate your statements. Officer Esposito, anything further from your side?
No, nothing further right now.
Just take a moment, then I'll announce some findings. Okay, Mr. Pajewski. So in charge number 1, the condition of GPS, I am making a finding of probable cause based on the evidence submitted in states exhibits A, D, E, and H. On charge number 2, the condition of obedience to the law, I am separating these charges into different parts as they're different. You have different things going on. So a no finding is going to be made for the Connecticut offense of the operation of a motor vehicle without insurance, and then Massachusetts offenses of marked lane violations and unregistered motor vehicle violations, because as stated by their offenses, at least these are 3 are considered violations, so they're not crimes. So making a no findings for those specific charges against you. I am going to make a finding of probable cause for the remainder of the charges against you under obedience to the law based on the evidence presented in states exhibits A, D, F, G, L, and M. On charge number 3, the condition of travel, I'm also making a finding of probable cause based on the evidence presented in states exhibits A, D, F, and M. And lastly, I am making a finding of probable cause on charge number 4, the condition of driving based on your admission in today's hearing, as well as the evidence presented in states exhibits A, D, G, and K. I'm also going to find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await the revocation hearing. So the records office at the facility will be notified this. Officer Esposito is now aware. So what happens, Mr. Carducci, is you have pending charges, so we cannot hold a revocation hearing until those pending charges are completed. So once they're completed, Officer Esposito will note, or whoever, the Pearl Community Services will notify us here at the board that your pending charges are concluded, and then we'll schedule a revocation hearing to determine whether or not you have violated your conditions of parole. At that revocation hearing, myself or another hearing examiner will determine if you did violate, and if so, make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Do you have any questions?
Yes, I think yesterday excuse me. I pleaded, for the ticket yesterday, that should be, I pleaded, guilty to that thing, and that should be all taken care of yesterday. That court case should be, all said and done as of yesterday.
That's the Connecticut charge?
Yes, that should be all said and done, and, it's all, yes,
So that-
yesterday.
Perfect. So what happens with that charge is technically Polk Community Services has 14 business days to let us know of that. However, you still have pending charges in Massachusetts. So once those are concluded, we'll,
What do I do about the signed thing that I have from him? And I have the materials at home, and I gave him 30 $100 bills, brand new. What do I, that's just, I mean, I have the paper, I have him sign his signature and everything. How does that go about? I mean, how do I, I mean, here, how do I call Mr., how do I do that? I don't understand why somebody couldn't just call him and say that I'm here and due to that fact, because I'm sure if someone called him, he would, I guess the times are messed up when he did that. He didn't call back up and say that he got it back because he's the one that ordered the materials, those special materials. They just went to Mass instead of going to the other material place. It's just like a one big, I mean, I've been, in fact, in business for 43 years of masonry. I have never once in my entire life even called back for a leaky chimney. Never more of this. This was just a time thing of the materials being ordered. I mean, you can go back, look at my business record, and I have nothing whatsoever at all as Mike's Masonry and Chimney Sweep, nothing. In fact, if you called him, he would say that he got his money back and I have the materials that are there right now.
yeah, I understand on that. On our end, it's that there's a pending court case in Massachusetts that needs to be completed and concluded before we see you again. Officer Esposito, do you have anything to add?
Yeah, actually I do. With regard to the Massachusetts case, I'm still waiting to hear back from them whether they're going to extradite him for that. It's looking like it's only going to be a Massachusetts warrant for him for a failure to appear, which I talked to Mr. Krajewski about it when I served him for his hearing, that he didn't show up to court on January 7th of this year. So they actually issued a failure to appear warrant for him. But I'm waiting still to hear from the state's attorney whether it's going to be extraditable or not. They say it's looking like it's not going to be.
Yes, the problem. Oh, I'm sorry, Mrs. Esposito. I didn't mean to interrupt you. I was just saying, when I was going to court that morning, I was on the video thing just like this that morning. And the judge told me to make sure that I send him over the thing saying that I was in the sober house at that particular time and I couldn't cross the state line. I went down to the office at Edgar and I talked to Amanda, which this is the text message on my phone says that she was going to send over the judge saying, yes, that I'm in the sober house in Bank Street in London. And apparently I thought that was.
So I'm gonna have to. I have another hearing. Unfortunately, we can't hash this out here, Mr. Krajewski.
Oh, okay. I'm sorry.
No, it's okay. I do. This is something I don't know if Officer Esposito will continue to monitor and help you with. But we can't move forward with that revocation hearing until she figures out how she wants to proceed with it. Basically, okay.
Okay.
And I don't know. I don't want to put words in anybody's mouth. It sounds like she's doing what she needs to do.
Oh yes.
Yeah. I don't deal what's happening. But we'll be notified by Officer Esposito when it's time to schedule that revocation hearing for you, okay?
Okay, she's great. She's gonna do it. She's doing it. She's doing the right thing.
Seems like she's doing the right thing. Absolutely, I agree. So this does conclude the preliminary hearing for Michael Krajewski, ME number 187569. All right, good luck to you, Mr. Krajewski.
Thank you. You have a good day as well.
Hopefully we'll see you soon, okay?
Okay. Bye-bye.
Bye, have a good day.
You too.
Hello? Oh, I thought they answered.
I'll dial them again for you and see if I can get them to join.
Thank you. Hi. Oh, I saw him in the door.
Moving on shortly.
Yeah, no problem. Thank you so much.
You're welcome.
Excuse me, sorry, sir.
Yes.
Just an FYI to you, when I do see him, it might be a little bit short because we haven't gotten paperwork in, so I don't know if that matters to you. It won't be a long hearing though.
Oh, that's fine.
When it gets here. Thank you.
Yep.
Is she on?
Mr. Lewisman, how are you?
How you doing today?
Good. Thank you. Yeah, it'll be pretty fast, unfortunately, if you just want to hang by, officer. So Mr. Lewisman, I just want to put in the record that this is your scheduled preliminary hearing. And unfortunately, we didn't get the paperwork in. It wasn't actually due until today. Unfortunately, so we scheduled this a little bit too prematurely. So what I'm gonna do is continue your case to next Thursday, April 23rd. And I'm gonna see you then for that because the stuff should be in from your charging officer by today. And then we'll get you a copy of the evidence and schedule you for next Thursday, okay?
All right.
All right, do you have any questions for me?
Nah, no questions.
All right, I'm sorry to make you come all the way down for this, but you were on the docket, so we just want to make sure we see you and keep you informed, okay?
Thank
All
you.
right, so I will see you next Thursday. Have a good day.
You too.
Bye.